This morning I've listed 2 summonses, one brought by the VGSO, the VLSB, in relation to the suppression orders, and a second summons, which I confirmed could be listed today, which is the summons of Mr. Kuksal. I think as I told you the last time that you all appeared before me, I'm sitting in the practice court at the moment, and the practice court has been particularly busy these last few days, including later today. It's not my intention to deal with all matters today, but I did, Mr. Kuksal, permit your summons to be filed today, because there are some matters in that summons that I want to deal with now. In particular, your summons filed yesterday raises 3 matters. The third matter is that you seek some additional time to file the material in support of the appointment of interstate judge application, and I felt that it was important to deal with that application expeditiously. There has been some exchange of correspondence between my chambers and the parties in recent days, in which my chambers indicated that a short extension of time would be accommodated, and I wanted to indicate that in relation to that third item on your summons, I intend to make orders extending the time for Mr. Kuksal to put on that material to next Wednesday. I think it's the 22nd. I'm not intending to hear from the parties about that. I'm just going to give you the leave to do that.
Thank you, Your Honor.
I do agree that I think, having looked over the transcript, there might have been a misunderstanding as to what you were talking about and what I was talking about in terms of how much time you thought you might need to do that. But I want to be clear, that material that I've asked you to file is confined to the interstate judge application.
Yes.
Yes, okay. Now the first item on that summons is your request for the Prothonotary to produce documents, and I don't propose to deal with that this morning because you foreshadowed putting on affidavits. But as I sit here now and just before coming into court, the last piece of correspondence I had from you, Mr. Kuksal, was a draft affidavit, but without the exhibits, and I think the email says that you intend to file the sworn affidavit at some point this morning. I'm just not in a position to look at that material and deal with that substantively now, and so I propose to adjourn that. If the material comes in during the course of the day, and I feel that without prejudicing the other matters that I have in my list today, then I might try and deal with it later, but…
Your Honor, the affidavit was sent earlier. The affirmed affidavit was sent. I can confirm the time at which it was sent.
Well, if it has been, Mr. Kuksal, I'm simply saying I haven't read it, and I'm not in a position to deal with that this morning.
Yeah, it was sent at only 8 a.m. with the exhibits. This morning.
Yes.
But it would be.
I'm just saying to you that…
Yes.
I'm the judge in the practice court at the moment. I've got an urgent injunction application before me later today, and I've got to be across 15 things at once.
I appreciate that.
If it has been filed, I haven't seen it and I haven't read it. So I will defer consideration of that item until once I've read the affidavit, and then I'll make orders in chambers about how I propose to deal with that.
I just want to raise one thing quickly, Your Honor, which I think is some misunderstanding about. In the communication that we had received from Your Honor's chambers, it was indicated that Your Honor was of the view that the allegations that we had raised against the Prothonotary had simply been raised via email, but all of the allegations that have been raised via affidavits, filed in the proceedings before Your Honor, and as the matters that we discovered were discovered, unless the Prothonotary obstructed the filing of evidence, which happened quite often, but we persisted anyway, the affidavits were lodged in real time. Your Honor had evidence of all the allegations raised about the Prothonotary, except for the ones that concerned evidence that took place in the last month or so, and the affidavit that has been affirmed this morning simply confirms that all those matters that were raised in the email within the last month or so.
I think I'm anxious to keep moving, and I'm not trying to cut you off, but I just want to say, I think you fairly observe that I'm new to this matter, and there is a great deal of affidavit material that's been filed on the court file. I'm not across all of it.
Yes.
I'm relying on your affidavit that you say you filed to bring me up to speed on the matters that you say are relevant, that I need to consider in relation to that first order that you seek. So I'm simply saying I'm not dealing with that this morning. I'll wait to read that affidavit, bring myself up to speed, and then I'll make orders in chambers about how I propose to deal with it. Fair enough?
Sure. The affidavit, though, only affirms the veracity of the content that has been sent recently, so it simply states that all the matters that have been raised via email are correct. But I don't wish to take any more time on that.
Thank you, Mr. Kuksal. In relation to item 2 on Mr. Kuksal's summons, what he seeks is an order that evidence filed in one of the 3 proceedings is evidence in all of the proceedings. I haven't turned my mind to the implications of that. If that were an order that could be made by consent now, I would make it. If it were to be opposed, I would defer it.
In my submission, Your Honor, that is the manner in which the proceedings have actually been conducted because both the state, or the VLSB, and us were lodging documents in that manner. The reason why we want to formalize the arrangement is because there have been instances where the Prothonotary has abused the informality of the situation, in that the VLSB's documents get sealed, even though one document has all the matters listed. This is discriminatory. Because when we do the same thing, our documents get rejected, so we have to make several times the effort administratively.
The way I think I'll deal with that is I understand why you request that order. I think everybody else now does too. I won't ask the other parties to respond now, I'll ask them to get instructions about it. If it's a matter that can be agreed by consent later in the morning, then I'll make the order. If there needs to be argument about it, then it's not something I'm going to entertain right this minute. Is that clear?
Yes, also, even the court cannot make that order, we will just file it in every proceeding.
That's what I thought.
It's not something that we cannot get over, in terms of presenting our case.
It struck me as an innocuous order to make, given the little that I've seen of this proceeding, but because I have seen only a little of this proceeding, I don't know if I'm stepping on a landmine by indicating my preparedness to make the order before I hear from the parties. If the parties can assist me by indicating whether they consent to that order or not, I'll make that one, which will deal with 2 out of the 3 matters in your summons, and maybe I'll be able to deal with the last one, being the Prothonotary documents thing also. I certainly can't deal with that today. That brings us then to the VLSB summons, and that leaves me with you, Ms. April. I would ask you to address me on that, and if you could in doing so tell me what documents you think I need to have available to me.
Yes, Your Honor, of course. Your Honor, before I do that, might we just go back to the 3rd order in the plaintiff's summons extending the time? I heard what Your Honor says about that. My only concern is the impact on the other steps in the other orders that Your Honor has made. That most importantly is that the defendants are required to serve any written response to the plaintiff's submissions by that same date, the 22nd of October.
Yes, I appreciate the difficulty. As I understand it, the application made by Mr. Kuksal really concerns the court, and whilst I might be assisted by submissions from you, ultimately it's an application for recusal of me in the court, and so I'm more concerned to give Mr. Kuksal the time he needs to put that application on properly on the proper material, and less concerned about giving you more time, or expanding the timetable, or adjourning the case. I don't see you as being particularly prejudiced by his late service of that material.
I certainly,
I mean, if you decided that you didn't want to put on any material, then that would be okay too.
Yes, okay, I've heard.
But what you shouldn't do is put on material on Sunday night.
I appreciate that.
If you cannot put some material on towards the end of the week, so that Mr. Kuksal has at least some time to look at what you say, then don't put it on Sunday night, because that will not help me.
Yes, indeed, Your Honor. I've heard what Your Honor has to say about that, and we will endeavor to.
Because you appreciate ultimately it's an application for me to consider on his material, it's not really to be seen by opposing parties to take my side.
Yes, quite, Your Honor.
Your Honor, I must state for clarification, we're not seeking Your Honor's refusal as such, and it's not the way in which we approach the matter.
No, you've made that clear.
Yes.
You don't have any grudge on, you don't have any issue with me because I haven't had anything to do with the case.
Yes.
Your application for the matter to be heard by an interstate judge is based upon an argument that the whole court couldn't hear it because of the circumstances surrounding your case.
The judges shouldn't hear it.
Yes.
I think one slight nuance which won't take too long is that I thought about the application further, and we're also not seeking the refusal of the court as such because the matter will still be with the Supreme Court of Victoria.
No, of course. But I understand how you frame it. It's not as though the court has no experience of these matters. It's happened in the past in certain matters. I'm waiting, as I've said, anxiously for your submissions, because it is an important application, and I'll have to give it very careful consideration.
Thank you.
All right, I want to go now to the suppression application. This comes before me in the practice court, because I'm sitting in the practice court, and I've got the carriage of these cases, but the query that I have, Ms. April, is this urgent in the sense that it might otherwise have come before the practice court? I want a sense of that. At the moment, the materials sit on the court file, but subject to an order made by me, under Rule 28.04. And I note that Mr. Kuksal raised in some correspondence with me, just bear with me for a moment, raised with me that order was made on the last occasion as a holding pattern by consent in a limited way.
Yes.
Pending your application to make a suppression order.
Yes.
Is there urgency about the suppression order being made today? Or is it something that I can think about once I've heard all the arguments?
I think it is something that Your Honor could think about so long as that holding order remains in place until Your Honor's decision on the matter.
That helps me, because I imagine from what has been exchanged between the parties, it seems likely there's a substantial argument to be made about that. Mr. Kuksal's put on a lot of material, and I'm just anxious to make sure that I understand how this might all work given that I cannot sit in this matter beyond, say, 1 o'clock today.
Yes, I understand.
Your Honor, we're confused. It was our view that the holding order had expired.
No, the holding order hasn't expired.
Your Honor, the orders that were made on the 8th of October explicitly said that unless there were new orders made on initially it was said Monday. Let me just bring up the orders.
Yes.
It is our explicit understanding that the order has expired and the documents should now be in the public domain. And I also want to be heard about what Your Honor queried with Ms. April about whether or not the suppression orders can be made at a later stage, because the jurisdictional questions that pertain here. Also, there are questions about the liability that arises for the plaintiffs in these matters.
All right. What I might do then is simply hear the application now, and then I'll come to you, Mr. Kuksal.
Your Honor, can we confirm whether the orders have been—
I'll look at that in a minute. I just don't have a copy of the order in front of me right this second.
I have the orders in front of me now, and the original orders that were made which I'm looking at. Your Honor, they said that paragraph 10 of the orders, by 5 p.m. on Wednesday the 15th of October, the plaintiffs file and serve an affidavit and so on. Paragraph 11 of the order, by 5 p.m. on Wednesday the plaintiff, it's actually.
I think you need to look at Order 6.
By 5 p.m. on Monday the 13th of October, any application by the defendant for the suppression orders must be brought by summons returnable by the Honorable Justice Finanzio. That order was extended until the 15th of October. Yes.
Order 6 does not expressly expire on its own terms. Order 6 continues to apply, and of course it makes sense, Mr. Kuksal, that was so, because the order that I make in 6 did not expire upon the making of a suppression order application. Order 6 continues in operation pending the outcome of the suppression order application. That was the reason for making it. It would have been a silly thing for me to do, to make Order 6, such that it then expired merely upon the making of a suppression order application before I'd even had a chance to consider it.
Your Honor, respectfully, what we have consented to, and the transcript will confirm this, were orders that the order that Your Honor was making, Order 6, would only operate until 5 p.m. on the 13th of October, and unless further orders were made, that order would come to expire. This is something that Your Honor had expressly confirmed or assured the plaintiffs that the court would make in terms of the orders. The wording had been agreed, and the wording was that the orders that the court was making would only last until 5 p.m. on Monday, and then if the applicants had filed an application, the court would make fresh orders that would, extend the suppression of the documents until a time set out in those orders.
So can I be clear about what my intention was? My intention was that if no application for suppression order had been made, I would have removed it.
But, Your Honor.
Pardon?
No application for suppression was made.
No, but permission was sought to extend the time, and it needed to be because the material—
No, I accept that. But what I'm saying is the order was extended until 5 p.m. on the 15th of October, and no application for suppression was made. The court still does not have an application for suppression before it. The application for suppression is a defined thing, and what Your Honor has are a summons which basically seek to circumvent the legitimate application process. The application for a suppression order must be supported by evidence, as is set out in S14 of the Open Courts Act. There is no evidence before Your Honor.
I'm going to hear Ms. April's application. I think you understand what I say about my intention in relation to Order 6. And the approach that I'm taking is that it's appropriate that the status quo, as I said on the last occasion, be maintained if an application for suppression order was to be made, and until such time as I've dealt with it. And that's what I intend to do. Okay?
Your Honor, the way we understand is that VLSB has represented that an application has been made. We are saying no application has been made. The court is to decide whether or not an application has been made, and if it decides an application has been made, then the orders have been extended. Otherwise, the court will rule that the order expired. That's the first issue. And even if the court rules that an application has been made, the court then has to decide whether the application should be granted.
Yes, and what I'm saying to you is I'm going to give you a chance to make all of those submissions to me once I hear what Ms. April has to say.
Thank you.
Okay? Thank you, Ms. April.
Thank you, Your Honor. The documents that Your Honor needs to have before Your Honor.
I do want to get them open because
There's a lot of material.
There's some material, but it's just slow opening them up.
Yes.
So I have your summons, which seeks the relief.
Yes. And a summons has been filed. In each proceeding they are identical.
Yes, and I have your written submissions.
Yes. They are dated the 14th of October.
I think so, yes.
Your Honor, if I could hand up a proposed minute of order that I—
Before you do, how do you hand it up to me and give it to Mr. Kuksal at the same time?
It's been emailed to Mr. Kuksal.
Has he got it?
If it's been emailed after the hearing commenced, I haven't seen it. But nothing was sent to us before the commencement of the hearing.
It's been sent moments ago.
They do this every time.
Hang on a minute. That may be true, it may not.
It's an ambush here, Your Honor.
It's not an uncommon thing for counsel at the start of a case to put up a proposed minute of order for the purpose of discussion. It is in my view an unhelpful thing when counsel do that against unrepresented or self-represented litigants, Because they do sometimes take the view, like Mr. Kuksal is apparently doing now, that it's an ambush. It would be much better if these things are done in advance because then I avoid arguments like this, but that is done this way, Mr. Kuksal. It doesn't mean that I'm going to not give you a chance to deal with it, and if that means having to give you time to do it, then I'll do that. But if in substance there's nothing new, or there's no prejudice, then I just want to get to the heart of the matter. But I am alive to the risk of prejudice, but I'm not going to act unless there is prejudice. Do you understand me?
Yes, I can tell Your Honor that Your Honor may continue.
Thank you.
I will go through the summons.
Thank you.
Your Honor, could I please explain why the proposed minute of order has only been provided this morning?
Your Honor, I'd say that would be unhelpful, because then I'd have to respond.
You're going to get a chance to respond anyway.
Waste the court's time, we accept that they have served it late. It's fine, let's move on.
I'll work out how I'm going to conduct the proceeding.
Your Honor.
I promise you it will be fair, okay?
Sorry.
Right. Now you don't really need to tell me why you've done it just this morning. It's not going to make any difference to me why. It's only going to make a difference to me, whether it substantially differs from the content of the summons that you've filed.
Okay, Your Honor, the only amendments that have been made to the orders that are set out in the summons are to Order 1B.
Yes.
At the end of that paragraph of 1B, the words contain the names of Person 1 and Person 2, referred to in Order 5 below.
Yes.
If it assists, Your Honor, I could hand up the tracked version of the orders?
If you could, please. And has that been provided to Mr. Kuksal as well?
It has not. It can be provided, as we are speaking.
Your Honor, you should not be given documents that have not been shared with us.
Well, it's about to be shared with you now, and I'm not going to look at it until you've got it, so that you and I are both in the same position.
Thank you. I've had a look at the summons, and I do want to raise a couple of issues when Your Honor gives me an opportunity.
Yes. Well, I'd rather deal with Miss April has to say, and then I'll deal with what you have to say in one hit, because I don't think it's productive of my time on this very busy day to go backwards and forwards.
There's just one thing I want to clarify, Your Honor, and I think it will help the court as well. I do not know the VLSB to have applied for a closed court hearing.
We've not, Your Honor.
They haven't done that. I don't think they had to either.
I do not seek orders in that respect, Your Honor.
So, Your Honor, then the orders cannot be sought without the court being closed.
I don't think that's right.
But in essence...
Let's hear the application.
Sure.
Could you... Yes.
I'm told by my instructor that the email with the tracked version of orders has just been sent.
Yes.
Without looking at that tracked version, Your Honor, I can indicate that...
I'm looking. I have open in front of me the original summons.
Yes.
That was filed, where order number 1 goes down to subparagraph E.
Yes.
And a copy of the now minute of proposed orders continues, F.
To O.
Through to O.
Yes, Your Honor.
And I'm right, aren't I? When I looked at that I thought, oh, was there a further amended summons filed? But no.
No.
These are the changes you seek?
Yes, they're the only amendments we seek, Your Honor. It is by virtue of having worked through the documents that have been provided by the plaintiffs.
My recollection is that when you put on the summons, you expressly indicated that you'd identified certain categories here, but that you were still going through the exhibits and reserved to yourself,
Indeed, Your Honor.
with my leave, the ability to add things.
Yes, that's correct, Your Honor.
All right.
And I should say that quite a number of documents have been provided by the plaintiffs. 431 documents to be precise, which amounts to in excess of 27,000 pages of material. Taking out duplicates, my instructors have identified 115 documents that they say are objectionable, and there are also a number of YouTube videos.
Objectionable as to relevance, or other objections, as compared with suppression.
No. My instructors have endeavored to review all of the documents, but it is possible that some have slipped through the cracks, owing to the sheer volume and the time in which we have had to review them.
Okay.
Mr. Kuksal, do you have that tracked version of the orders now?
Mr. Kuksal. But I'm right in saying, aren't I? You've just told me, it doesn't matter that he hasn't got, that NMR Kuksal doesn't have the tracked version. I don't think he's got the version that I'm presently looking at, which is the unmarked version.
He does, yes.
I have the...
Yes.
And what he should be looking at is items F through to T low.
Yes.
Which are the additional categories of documents to be caught by Order 1?
Yes, Your Honor. And Order 1B has that additional sentence at the end, or contain the names of Person 1 and Person 2, referred to in Order 5 below.
Yes, and as I understand it, Order 1 is really that the documents be admitted on a provisional basis.
Yes.
Subject to what will ultimately be your objection as to, so you're not saying that Mr. Kuksal can't rely on the documents in the hearing before me, but you are saying that you reserve an objection in relation to them.
Precisely, Your Honor. Yes.
All right. And then 2. Look, you wanted to point out to me what the differences were.
That's the extent of the differences, Your Honor.
Alright, well I'm now with you and your submissions to me as to the orders that you seek.
Yes, thank you.
May I clarify one thing, Your Honor? Looking at the additional orders that have been sought, it is clear from the orders that what is really being sought is the suppression of Ms. Joanne Jenkins' name and Mr. Howard Bowles' name, but the names were uttered at the last hearing and at the hearing on the 17th of June 2025, and this was also not a closed court, so the orders are nonsensical in that sense, and they mention,
Mr. Kuksal, that's not a clarification, that's a submission you might make to me later.
Okay, thank you.
Mr. Kuksal, it's not a clarification, it's a submission you might want to make to me, and I get that, but can I just hear the argument first, please?
Sure.
Your Honor has very eloquently explained the nub of my application today. The orders are sought in circumstances where my clients object to the admission of the documents that we have identified in the summons, and now in the order on the basis that we say they contain allegations which are scandalous, irrelevant, and inadmissible. And my clients intend to see that those allegations are struck out pursuant to Rule 27.7 at the interstate judge application. However, so as not to constrain
the plaintiffs.
The plaintiffs in the conduct of their application. We seek in these orders to admit the documents on a provisional basis, and subject to our objection, it's submitted that this will allow the admissibility of those documents to then be determined in the course of that application. My clients also seek orders that, pending the court's decision as to the admissibility of those documents, that the documents remain confidential and subject to a proceeding suppression order in order to prevent a real and substantial risk of prejudice to the proper administration of justice that would, in my submission, quite self-evidently exist if the documents were able to be published prior to the determination of their admissibility. What is also sought is, in effect, a pseudonym order in relation to the identities of 2 individuals which are the subject of the relevant allegations. Rule 28.05, as Your Honor well knows, and the inherent jurisdiction of the court, give the court the power to order that certain documents remain confidential.
So the question that I have there, the Open Courts Act.
Yes.
And suppression orders are close to the biggest club that a court can swing in relation to the general principle that things should happen in the open.
Yes.
And courts should be reluctant to make orders of that kind and do so in circumstances where the other alternatives are inadequate.
Yes, indeed, Your Honor.
So tell me why, for example, assuming I accept the principal submission that the allegations, just presuming that, we'll get to that in a minute, why 28.054 isn't enough.
Because a proceeding suppression order is also required to prevent the publication of that material, if and when it is deployed in the hearing of the interstate judge application, and things that are said about those documents and about the individuals in the course of that application, simply making an order under 28.054.
Well, it will deal with the situation up to the point where the hearing starts.
Correct.
But then once the hearing starts suppression, if I accept what you say about the content of the documents, suppression might be necessary in that respect.
Yes. If those allegations and the names of those individuals are deployed in oral argument or in written submissions in the course of the interstate judge application, then without a suppression order, either the plaintiffs or any third parties can publish what has occurred in that hearing. And that is why a proceeding suppression order, pursuant to SS 17 and 18(1) of the Open Courts Act is, in my submission, necessary.
And can I just be clear? I've read the Flitner affidavit, and in particular I've read those passages that are referred to in your paragraph 1b, but am I to take it that the efforts that you've made that you're not saying that suppression ought to apply to the content of the rest of that affidavit, even though you might take objection or want to make argument about its relevance or content?
That's correct, Your Honor. That is why my instructors have very diligently worked through the vast number of documents that they have been provided, so as to provide the court with a list of all the documents over which we say that a suppression order ought be made.
It should be done with a scalpel, not a club.
Correct, Your Honor.
If it's to be done.
Indeed, indeed. In my respectful submission, Your Honor, it is necessary to make a suppression order to prevent a real and substantial risk of prejudice to the administration of justice in circumstances where, as you and I have discussed, Your Honor, this morning, there are no other reasonably available means, other than making a suppression order, to prevent that risk to the administration of justice. In my submission, the allegations are quite obviously irrelevant to the interstate judge application, although it has not precisely been put by the plaintiffs precisely how they wish to deploy that material. And nor are they required.
Not yet.
Not yet. And nor were they yet required to elucidate the court as to the way in which they wished to deploy that material. It is difficult in my submission to see how that material could be relevant, in the sense of being able to rationally affect the probability of the existence of a fact in issue in relation to that application.
It's quite probable, and I haven't heard from Mr. Kuksal about this yet. My understanding of him exhibiting to misuse affidavit, the Flitner affidavit, is that there's content in the Flitner affidavit which goes to his defense of your application for summary dismissal, but there is also material that might go to his application for the matter to be heard by an interstate judge.
Yes.
It's possible that the allegations that are the subject of your application don't even arise on the application for an interstate judge. They're part of what Mr. Kuksal might argue is the factual background that he says I need to know about when I deal with your summary dismissal application.
Yes.
If that's so, then I suppose I'll hear from Mr. Kuksal about it, but I'll say this to you so that he can take a note and address me on it later. But having read the substance of the Flitner affidavit that deals with these paragraphs, concerning who I'll presently refer to as Person 1 and Person 2, it strikes me that those facts, I can't see for the moment how those facts could be relevant to the appointment of an interstate judge.
Indeed, Your Honor.
They might be matters that have to be. I'm not asking you to address me on it now, Mr. Kuksal. I want to hear the application all the way through to the end. They might be matters that come before me later, such that it's not even necessary for you to make an application to have them struck out under S57 or Rule 27 or anything, because they're not sought to be deployed on that anterior application.
Yes.
The way I see that anterior application is principally an application to me on material about the institution of this court and the judges in it, and I think what I've understood from the materials so far is the suggestion of systemic bias.
Does Your Honor have a copy of the notice of constitutional matter that the plaintiffs have?
I'm gonna hear from you later. If you want to tell me why I'm wrong about that, you can, but later. Go on.
Your Honor, we say the Flitner material is irrelevant, and we also say it is scandalous. It is of a highly personal nature, and we say it is unnecessarily and unjustifiably injurious to the personal character, integrity, and standing of the individuals the subject of that material. And as noted in my submissions, a number of other judges have found that to be the case.
We object to that.
Well, I was just about to say, they're not hearing this application.
Indeed, Your Honor. For those reasons, Your Honor, we say that the confidentiality orders and the proceeding suppression orders ought be made. Unless Your Honor has any further questions for me, those are my submissions.
No, I understand how you put it, all right, Mr. Kuksal.
Yes, Your Honor.
Before you start,
Yes.
there is a large volume of material, and it's fair to say in the time that I've had available, I've not had the opportunity to look at every single document in that large volume of material. And so you say to me, Ms. April, that you have attempted to deal with this by scalpel rather than club.
Yes.
It would be of assistance to me to have filed by you the documents in respect of which you claim I don't need to define them. You've defined them in the order, the documents. Because I can say this for a fact, given the expansion of the category of documents that you want me to make an order about, I haven't looked at them all. I won't be making any orders today until I have looked at them. But I would like you to file a folder of the documents over which you claim, the documents as defined by your proposed minute of order.
Certainly, Your Honor. We have in court a spreadsheet listing all of those documents, and that, together with all of the documents, can be filed with the court.
Yes, I'd like them because there's a lot of material, and by saying there's a lot of material I want to be expressly clear that I'm not saying that in a disparaging way. There just is, as a matter of fact, a lot of material.
Yes.
It would help me, given the time I have this week, to have the precise material about which you complain compiled in a folder that I can review conveniently.
That can be provided to Your Honor's chambers immediately after court, and to the plaintiff, of course.
Okay, because it may well be that after hearing Mr. Kuksal, I adjourn this. And depending on the busyness of the practice court next week, it'll come on next week for either further argument or ruling, or it will be adjourned to day one of the hearing depending on how quickly I can get through all the material.
Yes, Your Honor, indeed.
Yes. Mr. Kuksal,
Thank you, Your Honor.
you understand what I've just said there?
Yes, Your Honor. But I think I'll try my best to get Your Honor across the essence of our arguments, in a way that doesn't necessarily presume that Your Honor is across the material. I was preparing submissions in a way that I could assist the court in understanding the core of the arguments that we...
I appreciate that.
So the first matter that Your Honor...
Before you start, can you tell me, just so that I don't delay you, which documents you want me to have open while I hear your arguments?
Okay, yeah. So for the suppression order application, the documents that we would like Your Honor to have as a must are, firstly, the notice of a constitutional matter that the plaintiffs have filed, and it was sealed on the 13th of October at 1:11 p.m. It's also one of the documents that the VLSB seeks to suppress.
Yes, just bear with me for a moment.
Yes, The second document that we need, Your Honor, to have is a copy of the so we have filed in relation to this hearing the following submissions. The first set of submissions is dated the 13th of October. It was sealed on the 14th of October at 3:31 p.m.
Yes.
The title of the document is Relevant Authorities. That's the first set of submissions. The second set of submissions was filed on the 16th of October at 10:05 a.m. The title of the document is The Plaintiff's Submissions. There are appendices to that document.
So can I just be clear?
Yeah.
There are a number of submissions, including an amended submission, a document entitled Amended Submission, that you filed.
So it's an amended version.
I'm interested in looking at the one that I need to look at.
Yes.
So is the amended submissions dated the 16th of October?
Yes. So, Your Honor, the only difference in the amended submission.
I'm not worried about what the differences are. I just want to know if it's the up-to-date one that you want to rely on.
So both were lodged on the same date. The amended submissions have not been sealed. They may have been sealed during the hearing, but the sealed one that Your Honor may have are the original ones, not the amended ones, but it will not make any difference for the purpose of this hearing right now.
Well, when I was preparing, I read the amended submissions on the assumption that they were the most up-to-date ones, and they're the ones I've marked up. So is that okay?
Yes.
I proceed.
That's good.
All right.
Yes, so let's work with that. So that document, so I just identified 2 submission documents. Then there's a third set of submissions that has been filed this morning. It's dated the 17th of October, it's been sealed now. It's also called the Plaintiff Submissions. The first page has an index.
I have that too.
The fourth set of submissions is not relevant right now because it pertains to the subpoena or the disclosure application, so I'm not going to refer to that.
All right.
So what Your Honor needs really at the moment, documents and then to it.
I've got 4 documents. I've got the notice of the constitutional matter, the relevant authorities document, the amended submissions dated the 16th of October, and the plaintiff submissions dated the 17th of October, 2025.
Yes, and then we would like Your Honor to have the Flitner affidavit, not the exhibits, and also the affidavit of Ms. Yu, that's dated the 4th of March, 2025. It was exhibited to the affidavit, but also filed separately in this proceeding.
All right, I haven't got those affidavits yet.
We also shared a copy of it with Your Honor's chambers recently, but you can get someone to help you with that later.
Just hang on a minute, Mr. Kuksal. Ms. April, I think, is going to hand me up a copy of that affidavit you've just referred to.
I can hand up to Your Honor a copy of the Flitner affidavit if that assists.
Yes, thank you. Flitner affidavit and then the affidavit of Ms. Yu dated the 4th of March 2025.
I haven't got that, but my associate's taking a note. Just for her benefit, I can't find the notice of the constitutional matters in the…
Your Honor, I can hand up a copy also.
Excellent. You don't mind if the notice of the constitutional matters is handed to me?
No.
All right. I have that now, and I can't find the affidavit of Ms. Yu, dated
March 2025.
the 4th of March 2025. Are you going to deal with that immediately, or can we start?
Yes.
All right.
And also there's one more affidavit, that's the affidavit of Ms. Xu. Well, 2 more affidavits actually. The second affidavit is dated the 28th of March 2025, also filed in this proceeding.
Yes.
And then there's an affidavit of the 31st of October 2023, also filed in this proceeding.
All right.
And in addition to that, there's a notice of assessment outcome from IBAC that we had shared with Your Honor's chambers, I believe, on the 13th or the 14th of October. Yes, you confirmed that.
And these are all relevant, you say, to the present application for suppression?
Yes, but I will simply refer to them very quickly, and Your Honor can check the contents later on.
Will you refer to them by pinpoint references?
Yes, when I refer where the documents is voluminous, I will refer to them by pinpoint references.
Thank you.
Where if it's a 1 or 2 page document, then I don't think that would be necessary, but I can do that as well.
All right.
So, Your Honor, I would like to go about the determination of the matter in a systematic way. And the first thing we submit that the court has to be absolutely clear about is what the basis of the authority that the VLSB seeks to invoke is, and in that sense we say that the manner in which the VLSB has presented this case is deliberately problematic. Those documents that I've referred to will demonstrate that, and it is deliberately. It is that way because of the fact that it will not have a legitimate basis to make the application, the acting NSO in particular. I want to point out that when the summons were filed, there was no pseudonym order that was raised. There is no new matter that has arisen since the filing of the summons that could require a pseudonym order to be introduced. The reason why that has happened is because the application cannot be made without an affidavit, and they cannot file an affidavit because of, Your Honor. I actually also want to refer Your Honor to the transcripts of the 21st of May 2025, and the excerpt of the transcript of the hearing on the 8th of July 2025. Those are the hearings that took place in the federal court. I have written an email explaining the basis of the revised. It's not for what the judge has said, but it's for the manner in which the case was presented by the parties, and that will give the court a good insight into why the VLSB is conducting its case the way that it is currently conducting its case.
Can I ask you, if you like, an anterior question?
Sure.
I understand, having read the Flitner affidavit in particular, that there are, and you said this to me the last time when we were talking about the adjournment application and the nature of the proceedings that VLSB bring, which is effectively to seek summary dismissal of your current proceedings, that you will need to explain to me the full context before I rule on the summary dismissal application. But those aspects of the Flitner affidavit, which deal with, I'm going to say person 1 and person 2 now, I don't understand how those matters are relevant to the application for an interstate judge. On that affidavit material, there's no connection between the experiences of Mr. Flitner and any member of this court. It seems to me that your application for an interstate judge is an important application, and one that will occupy my thinking. But I'm concerned to make sure that I have the material in front of me that is relevant to that. So what I'm getting at, I suppose, is if that material doesn't have a bearing on that application, then it sort of takes the urgency of all of this away for a bit, doesn't it?
Yes, Your Honor, but I appreciate why Your Honor has the view that Your Honor has, because
I don't have any view yet. I'm asking you to tell me why it's important.
So I'd request that Your Honor think about what I'm going to say as if it was a completely different matter that Your Honor has no awareness of.
Okay.
And what I want to say to Your Honor is that in this new matter that we're talking about, there are two parties. One party is an estate agency, but the most important role in the administration of justice. The other party is a self-represented litigant, and the self-represented litigant is concerned about the procedural fairness that they may expect from the court.
From the court?
From the court, yes, and when I say the court, let me clarify, I'm referring to the abstract concept of the court process, not an individual.
I understand. The court exercising powers, whoever might constitute the court from time to time.
Yes, I think a better way of putting it would be whether or not their right to a fair hearing, as it is defined in the Charter of Human Rights and Responsibilities, and as to the Constitution, and the common law that interprets it, would require that they have to.
I understand how you put that.
The person is concerned about whether or not they would have all their statutory and common law rights respected during the course of the determination of the matters before the court. It is also the case that the self-represented litigant is absolutely convinced, and believes that it is a matter of an uncontroversial fact, that in previous instances, the same court has not respected the rights. Whether or not has actually happened, let's leave that aside, but it is the litigant's—
You would say a different judge of the same court.
I'm not making that distinction just now.
Then I'll ignore that distinction.
It's irrelevant. We're talking about, so in this matter that I'm talking about, Your Honor is not the judge.
Yes, sure.
This is a court experiment. We have two parties, they are before a court, no judge has been assigned, and we don't know who the judge is, but previously matters between the two parties, the litigant believes to be a matter of fact, and a matter of, agreed fact between the parties, that previously the conduct of the proceedings has been such that the administration of the justice system brought into disrepute, and it is the litigant's firm view that that has happened, not because the court is in particular, or is particularly biased against the litigant, or has any firm apprehensions against the litigant.
Yes.
Because the litigant is really an unremarkable person in the sense that they do not have any substantial influence over anything. They're not political, in a mainstream sense. They not have very strong commercial or financial interests that can affect the manner in which the state functions. So the litigant is an unremarkable individual, member of the public, and there is no reason why the litigant should have been involved in the controversy where serious allegations have been made against the court, and the court's administration has been brought into disrepute, other than the fact that the litigant had legitimate claims against the state entity.
Yes.
Which it believes firmly that the state entity has stopped the court from policy determining through the exercise of improper influence.
Yes. So that's your theoretical. We're not talking about you. This is your example that you want me to, the paradigm that you want me to consider.
That's right. So what the litigant believes is that because the litigant is such an unremarkable person, there could have been no reason for the court to make extremely controversial orders or take extremely controversial steps.
Yes.
Steps that were extremely attention-grabbing and steps that will be talked about for a considerable time. The cases before the court were also, to begin with, all that exceptional. The litigant was complaining about the actions by a state body, And, on their face, the orders that the litigant was seeking were also unremarkable. The litigant, however, understands that because the court was concerned about the interests of the state body and how the preliminary steps that the litigant was taking may be used later on against the state body and a number of other things, the court's administration has been brought into scandal. Now the litigant—
I want to understand, without in any way making light of it, your theoretical paradigm has some similarities with your own case.
Yes, of course.
And in some ways, it's difficult for me to divorce the two. I suppose, though, what you say, as I've read the material so far, you have a—
Your Honor, it will help you if you persist.
All right.
Because Your Honor does not need to consider the specific facts right now, because the matters that I'm raising are matters of principle, which is why I'm raising the paradigm, to keep the facts separate from the principles.
Yes.
Right now needs to happen is that the litigant needs to be convinced that they can get a fair hearing. Because let's presume that the litigant is a reasonable person, and in that sense they have no distinction from the reasonable observer.
Yes.
In QIFM, the court recently found that when it needs to be assessed and decided—
Don't distract yourself from the paradigm. I want to get to the end of the paradigm.
Well, the thing is that the distinction that the reasonable person is generally not one of the litigants is irrelevant here for the purpose of the paradigm, and I can prove that on authority.
Okay.
So what needs to happen is that in order for the court to decide the matter uncontroversially,
Yes.
the litigant needs to be convinced that the court may hear the matter in a way that will secure all of the rights of the litigant.
Yes.
Okay, so not that the judge will be— the three constitutional requirements are competent, independent, and impartial, but that the process will be respected.
Yes, but can I just stop you for a minute? Because I really do. I've got a busy day ahead of me. And I'm very keen to get to the point as fast as I can.
So the point—
No, just wait a minute, because I've got a fairly good sense of what I feel I need to know in order to try and deal with this application as quickly as I can. The application that's coming before me Monday week is an application by you for the appointment of an interstate judge. The material in the Flitner affidavit concerning Person 1 and Person 2 relate to Mr. Flitner's experiences of the state institution and not yours.
No, that's not right.
Well, hang on, so let me just finish what I was going to say. And they relate to what is said by Mr. Flitner to be the conduct of the VLSB, which may or may not relate to your—
No.
defense of their summary dismissal application, but I don't see how it relates at all to the appointment of this court, or to who presides over this case, because in this state, in every state, a judge of a superior court like this is called upon to determine the rights of the citizens against the state all the time.
Yes, but Your Honor, so I refer Your Honor to the notice of a constitutional matter. I find it quite unbelievable that the VLSB has read that document, is seeking its suppression, but still doesn't understand how we say that those allegations are relevant, because we have succinctly identified how they are relevant. What we're saying in relation to the relevance of the allegations is the following. This is page—
I've got the notice of constitutional matter in front of me.
Yes, so the punchline of the document, as it were, for the purposes of this hearing and the determination of the application seeking the appointment of an interstate judge, it's this. It's paragraph 7 on P9, paragraph 7, and paragraph 9. So, does the plaintiff rely on the Flitner affidavit?
Sorry, did you say paragraph 9?
Yes.
7 and 9.
Roman numerals. So what we are saying is that—
Just hang on a minute. Yes. All right, thank you. I've read. Command 7 antiques.
So, Your Honor, what we're saying is that the manner in which this proceeding has been conducted is testament to the VLSB's ability to distort and disrupt the judicial process. Because we believe that the reason why our summons were not being sealed, our affidavits were not being sealed, is because they contain allegations.
Yes.
Out of respect for the court's view, I am not going to name Person 1 and Person 2 henceforth consciously in this hearing.
Yes.
What we say is that that is why they are seeking the summary dismissal, and it is possible that Person 1 is linked to judges in the Supreme Court because of what is said in paragraph—
All right.
Paragraph 1 of 7. I'm not going to read it.
I think you've now explained to me in general terms, without going into the detail of the argument, what use you want to make of the material on the application for an interstate judge. And as I understand the position, no one is saying, least of all me, that you shouldn't be able to make those submissions to me in due course.
No, Your Honor, what we're also saying—
Yes.
Is that the way we are raising allegations about the court's integrity, and those allegations— the only check that exists on the court is the open courts process. What we want is to publicize to everybody what's happening in the hearing, so they can watch and check the court, so they can create pressure on the court to do the right thing. That's what we want to do. We do not trust the court fundamentally. We do not trust the Prothonotary to honor the we, and this is not about an individual. We think that the court process is compromised to the extent that, left to its own design, it will definitively incline toward injustice and suppression. And the fundamental issue here is that we think that the court is incapable of treating the VLSB as if it were just another litigant.
Okay, you may have that view.
It is the experience, Your Honor. We could not. I can tell you how many applications we have applied for in the practice court, which have not been even heard. I know why that has happened, because the notary, the other matter, Your Honor, is that we know that the Prothonotary tells every judge, and we are 100% sure that they have said disparaging things about us to Your Honor's chambers, and we say that Your Honor has an obligation to disclose that communication as well. I will set out in detail the basis of those assertions, but I have followed.
We don't have to do that yet. That's for the application on the...
But, Your Honor, we need the disclosure of documents, and I don't have to go through that right now, but what I'm saying is that these matters are interconnected. What we're saying is that the process is compromised. The notary views themselves as an employee of the state administration, not really as a particular office of the court. I have formed conversations with them.
I know, hang on, we're not talking about him today.
No, Your Honor, because what we're saying is that...
No. I'm going to remind you that I'm in the practice court, and I've got 2 hours for this matter, and that's it. And these matters are matters that I'm going to hear in a week's time, or at some earlier time when I hear the balance of your summons. But the important thing that I need to understand from you is your response to the VLSB's submissions, that the matters that they've specified are not scandalous, embarrassing, or otherwise necessarily dealt with by a suppression order.
So, Your Honor, if you please allow me to go about this systematically?
I will allow you to go about this systematically because that's what I need to decide.
To that point, Your Honor, in my view, what the court has to consider is this. What is the authority that the court is asked to exercise today? I was starting off with that, but the court wanted to know what the relevance of the documents was, and that's why I digressed a bit. The first thing that the court has to determine is, what is the authority that the court can exercise? VLSB, switching between relevance and a suppression order. They are completely different beasts.
I agree.
A completely different person, so I would submit to the court that we need to know first of all what application we are addressing. Because if it's an application for the relevance of evidence...
You're not dealing with relevance now, you're dealing with the suppression order.
Fantastic. So, Your Honor, if we are only dealing with the suppression order, then relevance is irrelevant.
It's not irrelevant. It will become relevant at the hearing.
No, but Your Honor, what they're asking, so they keep telling the court that they need an order pursuant to 28.05 of the court rules. What that rule says is that if the court has made an order that some documents are confidential, then the registry can withhold that from the public. That is not the source of the court's power or jurisdiction to make the documents confidential. That only explains what is to be done once the court has exercised some other authority to make the documents confidential. The authorities that we've cited in the submissions dated the 13th of October, which is called relevant authorities, clarify. And in particular, I take Your Honor to paragraph 13 on P14 of 30. It's Eastman v. Director of Public Prosecutions. Basically, it's an uncontroversial fact that summarizes the essence from the leading authorities.
Sorry, could you just repeat that? What page number was it?
It's P14 of 30. Submissions dated the 13th of October, paragraph 13. Eastman v. Director of Public Prosecutions, number 2. It succinctly summarizes the essence of what is at stake, as it's raised in the leading authorities, and essentially, Your Honor, there is a substantial debate within the judicial community and the legal scholars about whether or not there is any power in the court from its inherent jurisdiction or under common law to close the court or to suppress any part of the record in the first instance. The defining feature of a judicial proceeding is that it is conducted completely in the open, because the only check on judges is the
public scrutiny.
Exactly, but public scrutiny leads to public pressure.
I would like to think that judges were guided by what the law demanded, rather than what public pressure might be applied to judges.
To clarify, what I'm saying is that if they screw up, the public will know that they're dishonest in the performance of their duty.
It's about institutional trust.
Exactly. So I'm not saying that they make orders that are unpopular, and therefore they should be concerned about public opinion.
We're on the same page.
Exactly. So, Your Honor, then what I'm saying is that the open court system is a check on the court. Firstly, it is the utmost guarantee of institutional integrity as far as the court is concerned. In fact, it is the only guarantee of institutional integrity, and it is an open debate right now whether under common law the court has any authority to close the court. Even the camp that believes that the court may have some authority says that that authority is basically an aspect of its authority to prevent an abuse of its process, but limited to that and nothing else.
Yes.
The other camp actually disagrees that even then, the court can close the court of its own motion, because it's not a judicial process anymore if it's closed. Now, except if there is an abuse of the court process, like the kind that gets the court to essentially stay a proceeding, then only statute can give the court any authority to close the court. Now we can all agree in this instance that the abuse of the court thing does not apply because it cannot apply. No one has given any evidence. They keep saying prejudice to the administration of the court. They haven't identified what specific prejudice they are talking about, let alone the extent of the prejudice. All of those matters are matters that must be raised on affidavit. All the courts have clarified that. In fact, the Chief Justice of the Federal Court has escalated our matter to the full court of the Federal Court, because of our criticism of the judges who dealt with the matter so far. Now, then I take your honor to paragraph 15 of the same submissions. It starts on P16. This is the preeminent authority on disclosure obligations, Harmon v. Secretary of the State for the Home Department. That's where the term, Harmon, undertaking comes from.
Yes.
And what was said in that authority, basically, is cited by every other authority of the High Court. When it comes to open court principles, publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial. And then it was said that, I'm reading from P17, the first paragraph, which is a continuation of paragraph 15. To sum up this part of the argument, the common law, by its recognition of the principle of open justice, ensures that the public administration of justice will be subject to public scrutiny. Such scrutiny serves no purpose unless it is accompanied by the right of free speech, that is, the right publicly to report, to discuss, to comment, to criticize, to impart, and to receive ideas and information on the matters subjected to scrutiny. Now what we are saying is that a judge, and this is the paradigm again, so it's not your honor, but whoever the judge is that may hear the matter. Maybe they were not a former client of person A, or of any of person A's, fellow unregistered sex workers. But the judge will definitely have gone through their practice and their career as part of a very small and close-knit legal community where they would know these people or people connected with them, and they would know what the problems that will arise for those people, the careers that will be destroyed, and other things that will happen. And Your Honor can say,
So bear with me for a moment. For example, there are some members of the bar who are related to me.
yes,
If a case concerning them was to come before my court, I'd be required to recuse myself. If someone who I knew personally, whose conduct was the subject, or could be the subject of criticism in my court, then at the very first, I would be obliged to disclose that I knew that person. And I would be in some instances, just obligated to recuse myself, or to at the very least, bring that connection to the attention of the parties before me.
yes, but
I hesitate to interrupt you, but I want to be clear. It seems to me that these are matters that are going to the broader application.
no, it goes to the suppression order because what they are saying is that so what these parties clarify is that there is no open court hearing if any part of the documents is suppressed. An open court hearing, the purpose of it is to have before the public what is before you. The evidence that is before you should be before them. This is also clarified in R.V. Belhaj. It's a recent authority of the Privy Council UK. I refer to this in the submissions that we filed on the 16th of October. So I refer, Your Honor, to paragraph 3. The citation there is the authority.
Which submissions are these?
The 5th of October, the amended ones.
Yes.
So paragraph 3 has a footnote 1, that's the authority there.
Regina.
Belhaj.
Is that the one?
Yes, that's the one, Your Honor. Now first thing, Your Honor, is that these are criminal matters before you. Justice Joanne has already ruled that you're sitting in criminal matters. This concerns the conduct of criminal proceedings, whether the state weaponized its authority to maliciously prosecute people because they were a pain in their ass, to throw them in jail on indictable offenses.
Yes.
And we say that it was happening because of my activism and my activities to name and shame the public officials that I'm doing right now. This is why I was subjected to that mistreatment, and I'm saying that this is continuing. Maybe the names are changing, but it is that tendency for which I have been persecuted, the tendency to think that public officials are fiduciaries, and no one has a right to be employed as a fiduciary. It is something that they have to earn.
Yes.
And that you should be able to call them about, and everybody should know when people do the wrong thing, if they are in fiduciary roles. That is, Your Honor, there is evidence that has been adduced that IBAC has found the police to have engaged in misconduct, and they've accepted that it was criminal misconduct, but they refuse to prosecute them themselves. They've handed it over to the police. There was an email exchange that was discovered in those proceedings, and it clarified that the purpose for which I was being maliciously prosecuted was so a conviction could be recorded against my name, so then I could be kicked out of the country, because I was creating so much nuisance by making complaints, by publishing stuff against the police, and against the VLSB. So I was specifically being maliciously prosecuted because I was.
I have read enough to know that that is at the core of your complaint against the VLSB.
That's what's happening right now.
Yes, I'm not passing judgment one way or the other. I'm just wanting to confirm with you that I understand that to be the case. That is your argument. But I do want to bring you back, in particular.
So it's relevant to the
application before me is not that you cannot make submissions about this, nor that you cannot rely upon the Flitner affidavit on the public record, for the most part. There are discrete parts of that affidavit, about which there is an objection, about which there might be a legitimate argument as to relevance which I will have to ultimately determine, the content of which is potentially very damaging, to people who are not in the room.
Let's add those people to the, they should be.
They're not proper parties to your application for judicial review.
No, Your Honor. The application.
Adding parties to your application before this court is an application for judicial review.
Saying
what your
that application, Your Honor. I'm not going to that application. I'm saying what the VLSB is seeking is restraining orders to prevent someone's character from being destroyed, is what they're saying. They cannot make that application. I have authority for that. Only they can make that application. The state body.
You better take me to that authority, because that's the critical question I have to decide, right?
Yes, Your Honor.
I think we're on the same page about the importance of open courts, about the importance of institutional trust. We're on the same page about all of those things. I've read the submissions that you filed, and I've looked at the authorities in relation to those general propositions, but the critical question in front of me is whether or not the inclusion of this material is, in the language of the Open Courts Act, contrary to or prejudices the administration of justice because it's scandalous, etc.
Okay, Your Honor.
So you can take me to the authority.
But let me just point this one thing out. The fundamental relevance of the matter is this. They are asking Your Honor to do something that Your Honor, we say, has no authority to do. If Your Honor does it, then it will confirm our belief that Your Honor personally cannot hear this matter because of the fact that Your Honor cannot either conceptually grasp the thing, or is unaware of the law, or is compromised because of, or other subliminal relationship with the VLSB or their position. Because what we say is that the relevance argument is a separate argument that can only be had on evidence. First of all, you do not have a legitimate application before you. In my submission, respectfully, Your Honor, the court is not approaching this matter in the way that it must to ensure that it is itself following the requirements of the jurisdictional constraints that are placed upon the court to prevent the court from subconsciously overstepping. And this, it's a very formulaic construction. So the first thing that Your Honor has to consider is whether the application before you is an application that can be the subject of suppression orders. We say that it isn't, and the court has no authority. It does not have jurisdiction to make the orders. And if it does, then it confirms our belief that the court is ready to act unlawfully, or is incapable of taking the responsibility that it has seriously.
You better tell me why I don't have jurisdiction. I've asked you to take me to the authorities.
There's a number of reasons why, and I'll start taking Your Honor to the authorities. The first principle because of which Your Honor does not have jurisdiction, so I take Your Honor to P18 of the submissions dated the 13th of October. Political speech in this country is protected by the Constitution, and that includes public officials at every level. I particularly would urge Your Honor to read the bold and underlined paragraphs. So on P20, what we say the issue here is that there are public officials who we say do not meet the character requirements for the roles that they're in. That's the first argument, and we say that because of that, whatever they did was unlawful in the first instance, because the law, as it's identified in Aviva v. Law Society of New South Wales, 1979, 25 ALR 359, what was said in that authority is that when an officer of the court does something that is egregiously out of character for what the profession requires or expects of them, then they don't stop being a lawyer from the time the court rules that they have done that. They stop being a lawyer from the time they did retroactively. There are regulations under the Legal Profession Act which talk about a person conducting the affairs of their role in such a scandalous way that it is apparent that they were never suitable for their role and the implications that arise from it. So we say that the central argument is that these people, the actions that they took were unlawful because they never met the character requirements in the first instance. We say that the court has repeatedly stopped us from raising that argument in this proceeding and other proceedings because for one reason or the other, it's out there to protect them. We say that that is what the primary motivation of the Prothonotary has been, and that's why they're targeting us. I don't have anything against Mr. Ratcliffe, and he doesn't have anything against me. I'm an insignificant person. I'm talking about the court officials.
Sorry, that's the Prothonotary, right?
No, Your Honor. It's the same institution.
But no application is being made for a suppression order today about them.
No, but Your Honor, we're saying that what the VLSB has done is it illegitimately tried to achieve the effect of the orders that it is now seeking through you by corrupting the performance of the Prothonotary.
I understand that.
And that itself is irrelevant.
Please don't speak over me. I understand that, but I'm not dealing with that today. What I'm dealing with today is the suppression orders that have been sought in relation to the material specified in the summons and the minute of proposed orders, and what? I really want you to address that.
So the first thing I'm addressing the court about is the jurisdiction. And we say that in terms of the jurisdiction, firstly, we have a constitutional right to raise all sorts of scandalous matters against public officials.
No one is challenging your constitutional right to do whatever it is the constitutional right is.
Through the evidence that we file in the court, we have,
provided that it's relevant and subject to the court's supervision of that process, ensuring that we stay within the bounds of what the subject matter of that litigation is.
Absolutely. Now, relevance is the critical matter here. It is a very low threshold. Relevance means anything connected with the proceeding. We say that first of all, there's a very legitimate basis for why that's connected, because what we say is that firstly, the character of these people is manifestly colored by what they have done in those matters. There is a reason, Your Honor, why the profession has a requirement that people not bring it into disrepute. There is an underlying presumption that people have one character and that one character manifests itself in various ways, but it remains the same. They do not become different people in different contexts. The same people who have done horrible things, who are capable of doing horrible things, then get disqualified. And we say that these people, because they're capable of doing horrible things, we should win straight away, because what they did was unlawful, purely because they did not meet the character requirements to take the actions that they were taking. That's the first thing. The second thing is we say that the steps that they have taken against me, against Mr. Flitner,
Yes.
are steps that come from a playbook that they have perfected over the years. We have made very serious allegations about.
So just pause there for a minute. Your proceedings, the substantive proceedings, concern what VLSB have done to you.
Yes.
Not Mr. Flitner.
No, Your Honor. What we're saying is that this is how they deal with people like me and Mr. Flitner.
But whether they've dealt. The VLSB deals with many solicitors and lawyers in the state. Whether they've dealt roughly or unfairly or unlawfully with someone else has nothing to do with whether they have dealt unfairly with you.
Respectfully, Your Honor, that is completely wrong, because two reasons. Firstly, even if there was.
Well, you may say that, and ultimately you may have to appeal me on that question.
Yes.
But it does seem to me that, as a matter of logic and as a matter of evidence, the critical question in your proceedings is whether they have dealt unfairly or wrongly with you.
Yes, Your Honor. But what? Okay, there's two things that I want to say. Firstly, even if they were not a public body, we would have used the evidence as character evidence and tendency evidence.
But you can't do that in relation to the body per se. That's the problem with the argument.
No, but it's the officials at the body. You have decision makers at the body.
At the moment, we're getting into the relevance question, which we'll have to deal with ultimately, probably next time. But at the moment, as I read it, maybe you can point me to some parts of it. But in relation to the allegations made by Mr. Flitner, it doesn't seem that both persons 1 and 2 you've dealt with.
Yes, Your Honor, we have. That's what we've exhibited for Your Honor. Your Honor, person 2 who controls person 1. Person 1 is a subordinate of person 2. That's what Mr. Flitner also says.
Yes.
Person 2 is the person responsible for all the actions against me.
I see, okay, all right.
There is a personal conflict between me and person 2, and my position is this. I do not have a quarrel with the VLSB, the institution. It is only with person 2, who had usurped the authority of the institution, because he knows that I was coming after him, and he knows that, because my lawyer told him that.
Yes.
I had engaged lawyers to personally sue person 2 a long time ago, and following that, person 2 started introducing, Your Honor, this is the critical part.
Okay.
Person 2 goes to the police officer, who the IBAC has found to have committed perjury, and told the police officer that he can take all my court files in that proceeding from him.
So the question that I have for you, and ultimately it would all come to this, is how's any of this helpful in the application for the appointment of an interstate judge?
Because person 2 has connections within the state legal infrastructure, we say the person 2 has a say, indirectly, directly, or influence upon the appointment of judges through the recommendations that are made. And we say that person too, we know that previously judges. So, Your Honor, these people regulate the profession that judges operate under when they are practicing solicitors or barristers. They become friend with senior officials at the VLSB.
I understand the way you put it.
And when they're appointed as judges, Your Honor, Miss Shu is kicking me very aggressively to point out that in the Mockbell case, it was the same matter, and Your Honor, Miss Shu would like to be heard, and she's very anxious to be heard. So if the court would hear her separately.
Yes, I'll hear from Ms. Yu.
Okay. So, Your Honor, the person has taken specific steps in our matter.
Yes.
Our personal matters, Your Honor, are exhibited. Appendix A to the submissions that were filed on the 17th of October.
And so if... Yes.
One more thing. The second part is that we say that what we have to convince the court in our proceeding is that these people have broken their oath of office. They have maliciously recognized their authority to take adverse actions against specific individuals, and they've vilified those individuals, knowing that those individuals were innocent, to get out of trouble themselves. Now,
can I ask you a question?
Your Honor, just hear this. Please, 30 seconds. Let me complete this final thing. Very important. It is a character thing. Either a person can do that, or they cannot do that. If we can prove that they've done that previously, then we prove that they have the character to do it. Our task becomes so much easier.
Well, not necessarily.
Your Honor,
Because if they had never done it before and done it to you, that would be enough for you to succeed. The question is whether they've done it to you.
Yes, but if they have done it previously, it factors in the exercise of discretion.
All right.
And it's the relevant character and tendency evidence, and then the bureau.
And can I just understand that's how you put the material that is in the Flitner affidavit that is referred to in paragraphs 56.1 to 56.14?
Exactly.
All right.
It's because these people, we say, have a playbook that they work from, and there is a specific way in which they institutionalize corruption. And so, Your Honor, going back to, this is the relevance part, okay, but going back to jurisdiction, which is the only question before Your Honor, I would say, at the minute, I think Ms. Chu's part is relevant here, that the interstate judge was needed in the Mockbell matter because the Lawyer X scandal essentially had the OPP involved with the police and the person's lawyer involved with the police.
Yes.
And the OPP knew about that and didn't raise the necessary facts. In our case, the legal services regulator itself took over the practice, so it could ensure breach of privilege so I could be maliciously prosecuted. And person 2 is the person who specifically did that.
Person 2?
The police informant was told that he needs to contact person 2 to get my documents.
Yes.
Person 2 threatened my lawyer to abandon my representation or he would be destroyed, and then destroyed my lawyer for failing to.
These are, I think insofar as these are allegations that you make against person.
They are uncontested on documentary evidence.
Yes.
The VLSB has filed nothing in response for all these years, and now the police has been incriminated. Those police officers, the IBAC itself has found, committed criminal offenses.
All right. I want to bring you back to...
Your Honor, may I just say one more thing?
No.
The magistrate in the matter found that...
All right. I want to bring you back to the suppression orders that are being sought by the VLSB in relation to the material identified. You've addressed me on jurisdiction. I understand how you put that.
Your Honor, on jurisdiction. The first matter is that I say that the authorities clarify that if Your Honor were to make any orders, they can only be made on evidence. Without evidence, then nothing that the court can do.
You've told me that.
The authority for that, Your Honor, is...
Yes.
So it's paragraph 13 of the submissions of the 13th of October.
Yes.
I took Your Honor to that earlier, but Your Honor should read that thoroughly.
Paragraph 30?
3 of the submissions of the 13th of October, paragraph 14.
13 and 14.
Paragraph 13 and 14.
You've taken me to those. That's Eastman.
Yes, 14 and 15. And, Your Honor, it's the law, the statutory provisions. It's S14 of the Open Courts Act.
Yes.
And it's S18 of the Open Courts Act.
Yes.
The principle of open justice is an uncontroversial principle that...
We're at one on what the broad principles are.
Don't suppress the matter because of defamation. And you cannot say... So what they're trying to say is they're not really saying that the matters are irrelevant, because they cannot be irrelevant. Given that the same person is involved, relevance, the very low threshold of relevance has been gone. What they're actually asking the court to do is see whether the probative value of it is high enough, and so on and so forth, but that's not something that you can do at this stage. You do not have the constitutional authority to suppress a document because the probative value of the document is not high enough. What you have to do is determine whether they have identified a specific prejudice, then they have quantified that specific prejudice, and there's other constitutional impediments that they face. Firstly, the right party has to be the party who will be defamed, and I can give Your Honor authority about that. I'm just bringing it up. So, Your Honor, the authority is, this was News Digital Media, Pty Limited, VTE.
Is it referred to in the submissions?
No.
Can you just give me the name of the case?
Yes. News Digital Media, Pty Limited, v. Mockbell, 2010, VSCA 51.
Just say the citation slowly because I write slowly.
2010, 2010.
2010, yes. VSC?
VSCA, Court of Appeal of this Court, 51.
Yes.
Chief Justice Warren, Justice of Appeal Judges Buchanan and Byrne.
Yes.
So they set out the principles in that matter very clearly, and in paragraph 19 in particular, in interpreting the phrase, in relation to, a two-judge bench of the court took a contextual approach to give effect to the legislative purpose. The legislative purpose of S17A3 was recognized in Smith v. the Queen. So what they are saying is that you need to specifically identify what the prejudice to the administration of justice is. And then the right party needs to give evidence about what the prejudices will be. It's not a vague thing, and it's not that the potential for prejudice exists. It's the specific prejudice that will exist, because once the court has closed, Your Honor, the authorities that I've cited in my submissions, the 13th of October, they clarify that the proceeding is.
Your Honor, I'm not seeking a closed court order.
Sorry?
It is a closed court order.
I'm not seeking orders for a closed court.
Just.
Your Honor, if any document is not before the public, if any document is suppressed, it's a closed court order.
Well, there might be a debate about that.
Your Honor, we've had this debate before. Justice Downs, she ultimately accepted that.
Before Justice Downs.
In the federal court, it's an unremarkable principle, Your Honor, that if there is any document that's not before the public, how can the public judge what the court is doing?
I understand how you put that.
The point is the public should be able to see what Your Honor had before you and how Your Honor judged that, and if they can't do that, then there is no point in the court being open.
I understand that that's what you say.
But the term, closed court, has been used for this sort of procedure, even though the members of the public can attend the hearing, in the House of Lords and the Privy Council in the Belhaj, Regina versus a DPP proceeding that I identified, and in a number of other proceedings in Victoria and in Australia. The other authority for the right party is Fraser v. Evans, FRASER v. Evans, EVANS, 1969-1, Queen's Bench, QB, 349.
I understand that. As I understand the way you put it, any order suppressing the content of any evidence amounts to at least a partial closure of the court.
Yes.
And even though that's different to a complete closure of the court,
Yes.
it's nonetheless a closure of sorts.
Yes, and we say that in this case the implications would be even higher, because when we want to criticize the court we will be constrained from criticizing the court because we will not be able to have people look at the documents. So the prejudice to us is especially extreme because we do not trust this court.
Yes, but the documents that are sought to be suppressed are not a criticism of the court. You could criticize the court all you want in the application for an interstate judge without even mentioning these documents.
No, what I'm saying is, Your Honor, the way in which the court deals with those documents.
I haven't dealt with them yet.
Yes, but this is a theoretical. That's why I was talking about the paradigm. I'm not talking about Your Honor, but let's say the judge.
As I understand it, what you say is that if I make a suppression order in this case, that will just be further proof positive that this court is against you, and you'll make a recusal application against me. That is the paradigm that you've advanced, correct?
That's one aspect of the paradigm.
I understand.
But I mean, that's a fairly obvious aspect of the paradigm. But the more important aspect of the paradigm that I'm referring to right now is that, so for instance, we don't even have to use a paradigm. In Justice Downs' case, she suppressed the names of two individuals who I cannot name, and it is a restriction on my ability to criticize Justice Downs because I have to point out that these were the individuals, this is what they had done, and then she suppressed it, and it was completely baseless.
Can you just clarify something for me? Justice Downs was the one who made the suppression orders in the federal court.
That's right.
As I understand it, Justice Downs is a Queensland judge.
Yes. So she was appointed, ironically, because we complained that the Victorian judges could not handle the matter because of a conflict.
Okay.
That's the irony of it, Your Honor.
It's an irony, but it seems to also create a conundrum, because your application is that an interstate judge be appointed, and in the federal court, an interstate judge was appointed by the Chief Justice, who happens to be a Victorian judge, and the interstate judge was the one who granted the suppression orders.
Yes, and because of the scandalous nature of those orders.
The apparent conundrum, which no doubt we'll have to deal with on the 27th, is how can there be, where will we source a judge in Australia who can hear the case?
No, we don't say that she was conflicted because all judges in Australia are conflicted. What we're saying is that there are all these conflicts that arise when the matters are being considered by judges in Victoria. Now, in the case of Justice Downes, we say that she essentially, it wasn't the same issue, but it's not like that is the only issue that can arise when a judge takes over. In Judge Downes' case, essentially Ms. April lied on the first hearing about the matter. I'm just clarifying where the conflict with Justice Downes came from.
It's not profitable to do that because I don't need to decide that today. It's 11:45, and I'm still in the practice court and hearing an injunction at 1 o'clock, or 1:30 I think, so I really want you to. I think you've got a time between now and when we rise to convince me or to take me. Not to convince me so much, but to explain to me why these suppression orders wouldn't be made and shouldn't be made. And I think, as I've understood you so far, you've said that an application for suppression order needs to be supported by an affidavit from the person who might suffer the harm.
The harm, yes.
That's the first point. You say I don't have a proper application in front of me.
Yeah, sure, but
The second point, yes.
the second point is that the harm cannot be harm to reputation. It cannot be harm to all the other matters that have been raised, which, by the way, it has to be. So, Your Honor, there are specific courts that are used in this respect, and I will just read them out from the authorities if Your Honor gives me a few minutes.
I'm happy for you to do that, but I understand the broad point. So in addition to there being no affidavit in front of me, you say that the substance of the allegations can't be mere harm to the person. It has to be something more than that, or harm to character or reputation. That's what you say.
No, we say that any harm cannot in itself justify the suppression order.
Yes, thank you for that clarification.
No amount of harm can justify the suppression order on its own. What needs to be shown is that the specific context is such that the other matter, so the starting position, is that the court cannot be closed.
I know that.
Cannot be closed unless there is a very high abuse of process criteria. So what the court has to consider in those circumstances is whether we are deliberately targeting the person in a way that is completely fraudulent and is aimed at dragging someone who has no relationship with the matter and so on and so forth into this thing. Now, unless that is the case, which it obviously isn't, the court cannot actually suppress the record. That's the first matter. The second matter is that in order for Your Honor to even consider doing it, it must have some utility. There is no utility in this. What prejudice are you stopping? Because we're already telling everybody. What they're saying is that you stop documents that are already on YouTube in the public domain, which is absurd, completely absurd. There is no relevance of the matter. And the other matter, Your Honor, to the extent that they're saying that maybe reporters can pick this up and that up, everything is on the transcript. They can still pick it up. There is no relevance here. It's in the transcript of every hearing, and this is the mathematical construct. There is no legitimate aim that this application can advance other than them trying to prevent us from exercising our right to make a complaint against the government, other than the court being able to talk about that matter and consider that matter in terms of the judgment. So we will say that the Prothonotary is compromised because of this, and the Prothonotary then prejudices the judges in a way that they cannot do with the interstate judge.
Okay.
Your Honor, I can demonstrate that the Prothonotary tells judges that we make applications of this sort. And by the way, they will have to because of the things that I say about them. When I say those things about them, and probably every judge, they have to meet that judge, they have to address that. So no reasonable person will accept that the Prothonotary hasn't said something in response to what I've said about them. What they will have to say in response is that I'm doing something improper or exaggerating and so on. Those matters are not before me, and they should be before me because they're raising it with the judge in my matter. They're making assertions about me. I need to have disclosure of that. And we say that all this is connected with the Jenkins documents, that the Prothonotary is motivated to suppress those documents, and that's one of the contentions, and maybe their motivation is just that they think that we're abusing the court process.
It could be.
It doesn't matter because we think both of them are unlawful, and we think they should be fined for it.
I haven't finished. Let's say in your hypothetical scenario that the notary was motivated to reject a filing because it considered that the content of the filing was an abusive process or otherwise not in the correct form. Then,
I know that's what they've said to the judges repeatedly.
You asked me before to entertain your paradigm. I'm asking you to do the same. If the Prothonotary did reject a filing because it had formed the view that it was an abusive process, even if it had done that wrongly, mistakenly, why would that necessarily harm the administration of justice, that there are avenues for litigants to correct an error by the Prothonotary?
I understand the question, and this is the answer to it. Whether they did it innocently, or with the best of intentions or not, is a matter of fact. It is a fact that a judge needs to decide after a contradictor has addressed the judge. It cannot be that the Prothonotary on its own says, I have the best of intention and therefore I did this. We should be given an opportunity to address that. We should be given the steps that they took, and then, this is how the administration of justice is restored. We allege what we allege against them, they defend themselves, and then the court decides. The court stays an open court, that this is what happened. This is what the Prothonotary did, and the Prothonotary is thereby exonerated. De NBUT. It cannot be that the Prothonotary asserts something, and it's accepted at face value, or the judge considers the reasonableness of the Prothonotary in the absence of the contradictor. It's not a judicial process. We're not saying that Your Honor should find right now that the Prothonotary did the wrong thing. We are saying we are entitled to make that allegation against the Prothonotary. All we need is a proper basis to make an allegation. We have a basis because it has happened, and it was not. It was so out of character for the Prothonotary's role. This is the compounding fact, Your Honor. The Prothonotary did not own up to it, and made facetious excuses instead of accepting the truth. Said something that was provably false, and did that under the pressure that I created for them, which was so they would lie under pressure.
I understand. These are matters that you will put. Can I come back because you were on your third point? You said no utility in making the suppression orders. So I had the first point, was no affidavit. The second point was, even on the way that it's put by the VLSB, it couldn't form the basis of an order for suppression. The third point was no utility. Are there other matters?
Yes.
So I want to come back to the other matters.
Public interest. We are saying that the Prothonotary perverted the course of justice, and we will bring contempt charges against him within the next week. We will file summonses.
Hang on, we're addressing now the suppression orders, not the notary.
No, what I'm saying is, Your Honor.
No order is being sought for suppression of anything.
Okay, if the court suppresses the document, it prevents us, and it also forecloses the court's intention that it will prevent us. If Your Honor can see that this document is going to be relevant and critical in this matter.
Which document? The documents that are specified.
In the affidavit and the constitutional orders. By the way, I don't even understand how the court can suppress the constitutional orders that has already been served on the Attorney General. And I don't understand how that can be because we need to have a conversation with them about it and give them more material about it. We have a right to criticize the Attorney General if they don't act on the constitutional orders to urge people to not work for their party or for them, because this is how they deal with constitutional notices.
Sorry, is what you're saying now directed to your point about public interest?
That's right, the public interest. But it also feeds into the consideration of the various prejudices earlier. But it's also a separate category, the public interest.
Yes.
So we say that the court cannot suppress those documents without necessarily suppressing our right to enforce checks and balances on this court and its officials, and to criticize the people who are supposed to enforce the checks and balances on this court who are basically public or political figures.
All right.
And what we say is that it is entirely because of the fault of the VLSB that the situation has arisen, that the Constitution notice has been sealed and served, because they took their sweet time to oppose the Constitution notice. Even in equity, there is the principle of laches. This is an equitable measure. Effectively, the principles that the court considers are.
I don't think the principle of laches is going to influence the outcome of this application.
Your Honor, it's directly used in the open court's principle that if a party delays the making the application, then the court becomes more reluctant to give a suppression order.
All right. And what delay are you talking about here?
The constitutional notice was, we filed the constitutional notice, we immediately told the court and the parties, we put them on notice that this has happened.
This is the 13th of October?
For the constitutional notice, yes, the 13th of October.
What is the period of delay that you say is the relevant period that I should have regard to?
So, Your Honor, it's obviously contextualized to the matter. So the 13th of October, we filed the document, we served it on the VLSB, and provided it to the court. The VLSB said nothing about it. It was only the following day that they, well, after 24 hours or so that they pointed that out. The other matter, Your Honor, is this.
All right, so just so that I know, the delay you're talking about is the delay of a day, yes?
It's the context of the matter and the document. But there's another issue as well, the notice to adduce tendency evidence that was filed in the federal court.
Yes.
We had foreshadowed that we would file the document well before the 6th of October. That is why they had started hinting about the suppression orders made by Justice Downs.
I think the notice to adduce tendency evidence referred to in the minute of order is the 24th of September 2025.
Sorry?
In paragraph 1, C of the summons, the date of the notice to adduce tendency evidence is recorded as the 25th of September, 2025.
No, Your Honor. It was filed in the federal court. The notice of use tendency evidence
I see.
was exhibited as the documents filed in the federal court.
I see.
X's affidavit. Now they knew about that, the affidavit filed. They did nothing about that until right now. That document is not confidential. Your Honor did not make orders to make that confidential. Up until now they did nothing about it.
That's true. Is it right that Miss is affidavit, isn't it?
Yes and no, but they were given a copy of it, and it was exhibited to Miss Crew's affidavit of the 25th of
6th, the 6th of October.
Your Honor, yes, that one. But the one that was done before that, it was exhibited to that one as well. In these proceedings, yes.
All right, thank you.
So it was basically the documents that have been served on them. They said nothing about it. Even on the 8th of October, they said nothing about it in the hearing before Your Honor.
All right, and I just want to clarify, this is another, if you like, sub-point of your argument about public interest.
No, this is a separate point altogether, that they have not conducted their proceedings with due diligence.
This is the next point, which is that because they've delayed.
No, it's not delay, Your Honor, so much. It's that they have not taken it seriously.
All right.
They have not taken the matter seriously. That's the core argument. The delay actually conceptualizes that.
Yes, so that's the fifth point. The fourth point was the public.
Yes, that's a very serious point. And Your Honor, the other point is it's a public interest point, but it's also a constitutional point. And it's the point that the court has to have an arm's length distance from the executive at all times.
Yes.
And not only does it need to have that, it should be particularly emphatic about it. In Strickland v. DPP, the High Court had emphasized, I believe it's paragraph 256, but I'll cite the particular paragraph. What was said is that in this country the courts do not exist in a continuum with the law enforcement agencies, and any suggestion that the courts are becoming an instrument or extending any accommodations or concessions to the executive bring the administration of justice into disrepute. That was the term that was used. And in particular, I'll refer Your Honor to paragraph 256 of that authority, and also 249 of that authority. And generally, much of that authority goes to that point, and I say that Your Honor should consider all of it. But what we say is that they are asking the court they're not making a proper application. Why did no one file an affidavit clarifying the exact prejudice? Because they did that, they tried to do that in the federal court, the affidavit got knocked out, and I cross-examined people. They incriminated themselves further. They know that I would have cross-examined them. There is no legitimate basis for this. Would have revealed a number of other things that I need from them. So they don't want to put anyone forward for cross-examination. The court cannot possibly know. The prejudice cannot be hinted, insinuated, or even indicated.
You've made that point to me.
But, Your Honor, this is the separation argument now.
Okay.
That's the point that I'm getting. If Your Honor relented in relation to a private party, people would think that maybe the judge made a mistake. If the judge relents to this part of this entity, that has a legitimate role in controlling the courts, in sponsoring judicial education.
Yes.
Determining judicial education curriculum, and in the nomination of judges and so on. People would think that the judge takes instructions from the VLSB. That's what we would think and say.
Yes.
So especially an entity like that, if it does not, we put them on notice immediately that they haven't filed an application. They have sealed a summons, S-184 application.
Well, I suppose might be made though, that just contextualizing how this comes before me today, is that this matter was listed for hearing on their application and the state party's application for summary dismissal.
No, Your Honor. No, that's wrong. You have already determined that there were no proceedings at the time.
No.
They committed a fraud.
No.
There were no proceedings at the time, Your Honor.
Mr. Kuksal, let me finish.
Yes.
The hearing of their application for summary dismissal was scheduled to occur in August and was adjourned by consent to the 27th of October to commence Monday week. We are here now because you asked for an adjournment on summons, and in that application, you filed an affidavit, and if my recollection serves me correctly, the exhibits in that affidavit were not all available for whatever reason at the hearing.
No, that's wrong. So firstly, I want to get this for the record. The hearing that Your Honor is referring to, the summary dismissal application, it was a hearing that was obtained by fraud, and the court could not have legitimately gone on with that. We would have raised that argument, Miss Suri. That was her argument, as I pointed out, and the court found that the proceeding had not in fact been reinstated at that time. I provided consent on the basis that the matter was being adjourned.
I see, yes, I recall.
Obviously at the hearing of the matter, I wouldn't have provided consent that the matter be reinstated nunc pro tunc, so the matter can be dismissed. The court should not even ask me to do that.
No, I'm not saying that it could be dismissed, so that the hearing of that application could be heard.
It could not be heard. There was no matter before the court. The matter only came before the court after you made the order. I put the evidence of the recordings in the transcript.
Yes, thank you.
It was scandalous what they did. Absolutely scandalous. What they did before Judicial Registrar Lorenz of the 18th of March. So scandalous that I was kicked out for saying that it was raised in the court, and the Judicial Registrar needs to do something about it.
Okay.
I was kicked out just for that. And so that's the first matter. The second matter, Your Honor, is that again, Your Honor is not familiar with this, but I had filed the material of the Flitner affidavit.
Yes.
With the court in May. I had provided to the chambers of Judicial Registrar Lorenz those documents in May and said that we would file them. They did not seek anything to restrict us because there was no basis. Then they went to the federal court on an ambush application to say that we are about to file this in the Supreme Court. So we didn't do this at the last minute. We have been giving them plenty of opportunities because, Your Honor, this hearing is taking place because I got it scheduled by forcing their hand because I wanted it to be heard in open court.
Yes.
And for them to lose properly.
Mr. Kuksal, I was only trying to convey that at the last hearing I didn't have the Flitner affidavit.
Yes, Your Honor. That's because Your Honor has just got on board. But the Judicial Registrar, judicial officer before Your Honor in this matter, had the allegations raised in the Flitner affidavit before them.
Okay.
It was given to them. It was foreshadowed that we would file this. They should have sought suppression orders right then to suppress us.
Okay. So that it...
What they did was they went to the federal court to stop us from filing it in the Supreme Court instead of applying here.
Okay, I understand how you put that.
I can give you the date on which we provided it to Judicial Registrar Lorenz, Chambers.
Yes.
I believe it was the 13th or the 14th, but I will send Your Honor's Chambers a copy of that correspondence later today. That was sent to Judicial Registrar Lorenz, Chambers about that matter. But it is, by the way, that is an open document, because it is an uncontroversial principle that any communication with the registry and the tables is an open document. I have a Court of Appeal authority in my case.
I don't need you to give me authority for that.
Yes, so that's already an open document in this matter, that the same allegations have been given to Judicial Registrar Lorenz's chambers and the registry, and we say that from then on the Prothonotary was carefully sieving through everything we were filing to look out for damning allegations against the VLSB. Your Honor, one of the motives of the open courts principle is that it helps the public get rid of institutional predators.
Institutional what?
Predators, especially when it's the government, whether or not...
I don't want to go back into a discussion about the principles of the open courts policy.
That's a public interest argument. It's actually in the Judicial Commission of Victoria has published a paper on the open courts principle. In that paper, the JCV has identified the principles.
I actually read that. I don't need you to take me to that.
One of the identified purposes is that it allows people to make allegations against the government, which then makes those allegations public, and encourages other people to come forward and give evidence. That's what they're trying to prevent. We say we have given evidence about this. So the submissions that are filed this morning, they are matters of public record that have been referred to, and what has been referred to in those submissions, which is basically an article that I'm publishing. At P2 it cites that the Ombudsman, Mr. Brown, back in 2009, initiated...
I've read that too.
So we say that the floodgates will open. They're already opening. They are trying to stop them from opening further. And what they're doing is delegitimizing the court's process in doing so, because what they're asking the court to do is so wrong.
I understand that that's what you say, and I've understood that across the different points that you've made. I want to now ask you, I'm noting the time. It's 12:15, and what I'm keen to understand is how many more points you have to make in respect of the application, because I'm also keen to give Ms. April the opportunity to respond before I rise.
Ms. Chu needs to say a few things. Your Honor, I want to clarify this. I think the way that the court has approached this is that it has given rights to an apprehension that the suppression order should be made, and I have to convince the court why they shouldn't, whereas it's the other way around.
No, absolutely not. That's not how I've approached it at all.
Thank you for clarifying that.
If you want to make an argument to me, you have to convince me of the strength of your argument. I'm not imposing a burden on you in a legal sense. It's clear that the burden lies with the moving party, and the principles that you've outlined concerning open justice, and the starting point being that courts are open places in the interests of transparency, and all of those things that you've mentioned, is the way that I approach this application. The burden lies with the VLSB.
It's the highest burden we face in the judicial process, because it's the burden that basically fundamentally raises questions about the integrity of the court, not just in this matter, in any matter, because the open court process is the only effective check on the judge. What the judge has to be always careful about is that the first thing that will happen is it will amplify the criticism about the judge.
I understand that.
Your Honor, There's another really important matter that Your Honor should understand.
Can I just say this? I'm keen to give Miss April about half an hour before 1 o'clock, because I want to hear what she has to say. Can you tell me how much longer you're going to be?
I can finish in 10 minutes, but Ms. Xu has been very emphatic that she wants to speak. Your Honor, I'll try to be as quick as possible.
I'm going to give you 10, so that I can give Ms. Q some time
That's ample.
to stand this matter down for 5 minutes for a comfort break. Then what's going to happen is you're going to come back and I'm going to put you on a 10-minute on your own words. And I'm going to be strict about that. I just want to be very clear. A clock will be ticking.
I will be quiet after 10 minutes.
If in the time available in the next 5 minutes you can reduce the 10 minutes to something less than 10 minutes, that will earn considerable brownie points for me and Miss Gusu. Then you'll have the opportunity to speak, and then we'll see where we're at after that. It may be that Ms. April doesn't have anything to say. I think I've heard the argument, so we'll see where we land at that point, but I'm inclined to give her at least 15 minutes but not more than half an hour. This court stands adjourned for 5 minutes. Do we have Mr. Kuksal?
Yes, Your Honor. I didn't leave.
Okay, alright. Well, I'm going to ask my associate to start the timer.
I thought, Your Honor, I was on an honor system.
No, totally fine if it's an honor system.
Yes.
But it's better that somebody else times you, because I'll get lost in the argument.
Appreciate that, thank you.
So my associate will start the timer, but when the timer's up, we'll move on to Ms. Xu.
12.35 is when the timer gets up.
The timer will go when I say go.
Okay, great.
Time starts now.
Now, Your Honor, I had previously provided the court with an affidavit of mine dated the 29th of July 2025. It was filed in a related proceeding. I had referred to it as well in the correspondence, and there was one time when I had accidentally provided an unsealed copy of it, and then I corrected it. Now that affidavit is significant, and can you please provide a copy of that, the 29th of July, Ms. Xu? I need that now and His Honor. So, Your Honor, it's been previously provided but we'll provide a copy again, meanwhile. That affidavit is incredibly relevant for 2 reasons. 1. In that affidavit, I have cited some of the critical matters that the studies will go to, and I will endeavor to file the list of studies with the court as early as possible. The rest of the documents will lodge by the 22nd. Now, in that affidavit, I have a summary of the research that I've conducted into the various cognitive processes that underpin the judicial decision-making process, and critically, I have identified in that affidavit some well-established, university-accepted scientific facts about the way the brain works. One of the most important of those peculiarities of the way the brain works is that the brain does not have a mechanism to understand something and not trust it, or be completely neutral about the veracity of the assertion. By that, what I mean is that if someone were to say that Mr. Nelson Mandela was a prolific sexual predator during his term of imprisonment, the natural process for any human being, this is scientifically accepted fact, and I've cited those studies in the affidavit, would be to first accept that mentally, then, through a critical process, reject it. The process of understanding something naturally involves the acceptance of its truth, in that the person who hears it would automatically imagine Mr. Mandela in that position, or whatever representation they would have. They would have something in connection with Mr. Mandela doing something improper, or if not imagery but a notion, a concept. It is impossible for a person to hear that and not think that, did this person do it? So that's the first thing. This is a critical issue when the state wants to corrupt the judicial process because it gets to make allegations before the judges. It gets to make them in a specific way, at a specific time, and it can influence the way the applications are brought before judges, because if it has a relationship with the Prothonotary, then they can influence which judge a matter is presented before, in a number of ways. By making an application on a certain day, by listing it on a certain day, by basically corrupting the process of allocation, because it's an administrative process. Judges don't choose their cases. The second thing is that humans have limited capacity for energy-consuming processes, and the human mind functions in 2 modes essentially. One is the instinctive mode, the second is the critical process. Naturally, it functions in the instinctive mode. It has to be forced to function in the critical mode in special circumstances. When humans are under pressure, when they are tired, the first process kicks in, and that's where again, the people that would reject after accepting that Mr. Mandela was a predator will be far less likely to reject that notion if they were tired. There are scientific studies that demonstrate that. The people that are So firstly, to reject that a person needs to be a conscientious person who challenges the things that are put to them. And then the more they are under pressure, the more they are under time constraints and so on, the less likely that are to reject it, biologically speaking. Then there are special physical structures in the brain that deal with social contract logic versus abstract logic. The matter before Your Honor is a typical social contract logic matter because it involves emotions. It's also salacious. All of those things, there's a separate part of the brain you have to expend specific energy, and there's a lot of obstacles in the way of judges doing that. Then judges are particularly ill-equipped to overcome biases. That's the outcome of peer-reviewed university-accepted studies. It demonstrates, I've cited those studies in the affidavit, and I will provide a copy of the affidavit again today.
This is the affidavit of the 29th of July?
July 2025.
Yes.
Which is part of the related proceeding but has been provided to the chambers. It was to be exhibited to my affidavit, which the Prothonotary wouldn't accept, so it was not filed. Basically what the studies show is that judges have all the biases that other people would have, but then they have the overconfidence bias. They think that because of their judicial training, and because of the position to which they have been deemed capable to discharge the functions of, they will not be susceptible to biases, and in that, they are particularly susceptible to biases. That's the overconfidence bias. The relevance of all of this is this. I know the Prothonotary has told Your Honor that Ms. Jenkins' affidavit was unnecessary, and I was trying to abuse the court process. Your Honor cannot possibly.
They've told me that.
Yes. From the pattern of behavior that the Prothonotary has exhibited so far, which I have minutely documented, and a number of things that I do with them, I do just to verify patterns, so I know that when I made those allegations to Your Honor, the Prothonotary D.
You've got a minute left, but I understand your point.
The Prothonotary would have had to say something in response. It would have been that affidavit, which was irrelevant to harm other people. You cannot disassociate the impact of that from the application before Your Honor now because D.
Can I just ask you one thing? If I've had no conversation with Prothonotary about the substance of that affidavit at all, does that change the submission that you make?
It's not that it has to be a direct communication with them. It's that Your Honor's view is that the Prothonotary daughter, and the view has been formed because of the representations that have been made to Your Honor, or what Your Honor's understanding of how the Prothonotary functions is. But all of those are matters that are intangible, and they influence subliminally. I'm not saying that Your Honor implicated anything wrong. What I'm saying is,
that's the buzzer, but I understand the point.
That affidavit was not sealed in that proceeding, because the Prothonotary improperly obstructed that, because that affidavit also exhibited Mr. Flitner's affidavit.
Sorry, this is the affidavit of the 29th of July?
2025. So that critically affected our bankruptcy proceeding, which is a different matter, but what I'm saying is that the Prothonotary...
I understand the point, and I'm going to go back and reflect on what you've said when I review the transcript of today, because I will have to turn my mind to those matters.
And so the point that I was making, if I could get 30 seconds because I was interrupted for clarification.
Well, you really weren't.
Yes, but the point that I'm making is that, Your Honor, this application before Your Honor is affected by the representations that the registry has caused Your Honor to be subjected to. And that fundamentally requires that we have access to whatever the Prothonotary has been doing, which again makes this relevant, because if you make the suppression order right now, that forecloses our application for disclosure of documents held by the Prothonotary, for instance, communication between the VLSB and the Prothonotary, which will also contain those things. NSO, from our perspective, it's not unreasonable for us to expect that would be the case.
All right. I'm going to stop you now because I understand how you put it, and I'll have a think about those things. I'm not sure at face value that I accept your last. I don't know that it unreasonably precludes consideration of the other matters, but I'm not.
No, it affects what I'm saying.
No, I'm not asking you to comment. I haven't looked at the Prothonotary material yet, and I will do that. Ms. Exu.
May I just say this? I have said that I will provide 2 documents to Your Honor. One is the original correspondence that was sent to Judicial Registrar Lorenz, Chambers, to which the allegations were put. The second document is the 29th of July affidavit.
Can I beg you to only provide me with those 2 documents?
Only those 2 documents.
I'm not in a position, and I'll foreshadow this now with you, to deal with lots of correspondence over the coming week. I'm going to be looking at your affidavit in relation to the Prothonotary matters, which is the 3rd point in your summons, and I'm going to be looking at the material that you file, and also deliberating upon this application. So if at all possible, keep the correspondence to Chambers to the absolute minimum necessary.
Absolutely, Your Honor. Thank you.
Measure, before we get started, can you tell me how long you think you'll be?
So I think I will only be 5 or 10 minutes because I would want 2 things. One is to make some oral submissions, and the opportunity to put all material before Monday morning, and the opportunity, because I want to make a very short oral submission, and also the opportunity to put our written submission, because if I do make a substantive submission, it will take more than what Your Honor has.
Okay, first of all, I'll give you 5 minutes to make your oral submissions, and tell me in the course of that 5 minutes what it is, in addition to what's been put by Mr. Kuksal, that you want to say.
Sure.
I'll just ask my associate to put the timer on, and let me assure you, when Ms. April gets up to address me in reply, she's going to have the timer on her too.
Can I ask for 10 minutes?
You can have 10 minutes.
So I want to make submissions on the Open Courts Act. I want to put them in writing. I think Mr. Kuksal had made submissions to the essence of it, but not to the exact wording of those sections about the Open Courts Act. So I will now have that in writing. Secondly, I want to have the court go through the material from the amended submissions, the documents that are the amended oral submissions. That's filed on the 16th of October.
But I've read those submissions and been taken to them. I'm cautious to make sure that there's not duplication here. I'm asking you to identify what specifically, in addition to what Mr. Kuksal has filed, you need to tell me.
There's nothing that want to make submissions on that.
I'm assuming, Ms. Shu, that you adopt the submissions that have been made by Mr. Kuksal so far.
Yes.
You don't disagree with him?
No.
So the question that I've got for you is, what else? He's done a pretty good job of explaining to me the basis upon which it's opposed. What else could you want me to look at?
So first, if you can go to the paragraph 14 of the amended submissions, I want Your Honor to actually watch the video for the second, third, and then the last.
You want me to watch those videos?
Yes, and all of Flitner's videos. They won't be more than 1 hour long.
So which videos do you particularly want me to watch?
So in paragraph 14, does Your Honor have?
Yes, do you want me to watch all of them?
So,
They're numbered, are they? No, they're not numbered.
the one that's next to footnote 9, 10, and 11.
Footnote 9, 10, and 11.
And then the next page. So you know the one Flitner describes. 1, 4, 9, 10, 11, 12. I don't think it will be more than 1 hour long, and I want to make submissions on
You want to make submissions on?
why they are relevant to the opposing of the suppression order, and why they are relevant to the application for the interstate judge.
The question of relevance I'm deferring, and I have actually looked at some of the videos. What is it in particular you would say about the videos?
So I'm saying that all of the allegations that they are seeking to suppress, they are relevant, firstly. And
We'll leave aside their relevance,
yes.
because that's going to be a matter that I ultimately have to deal with. In relation to suppression specifically, what is it about them that you want to say?
So with the suppression order, what I'm saying is currently there is an interim order, as I understand, and section,
There's just an order preventing access to the documents.
but is a suppression order.
Yes, it is a Your Honor. It's supposition. It's an interim suppression order.
I understand how you put that. Go on, yes.
So my submission is that currently there's an interim suppression order by Your Honor, and S20 of the Open Courts Act says that if the courts or a tribunal makes an interim order, then the court must determine the substantive application for suppression order as a matter of urgency. What Your Honor is proposing to do is that the interim order is not so urgent because it can wait until their application at the evidence happens. And my submission is that that's not how order in the Open Court Act operates. It is only under very limited circumstances where the courts can make the proceedings suppression order, and none of them is for a party to wait until a party to strike out the evidence. That's what they ask this court to do. So I understand that there is an urgency in the substantive suppression order application to be heard. And I want to first inquire because, as a self-represented litigant, I fail to understand what is that VLSB say that is such a prejudice to the course of justice by filing those evidence that they seek to suppress. Secondly, Your Honor, Ms. April says that there is only one additional order they're seeking, but the ones that I have received from courts, I think I see many, many more that they have added. Which again, a lot of them are published. Some of them are filed with the federal court. They didn't ask for any suppression in the federal court, to the Supreme Court to ask for a suppression for the federal court filing. I fail to understand why that is.
Are you saying that in the minute of proposed orders there are?
Yes, the order extends to us during there are many additional, so I can read them out. Yes, the ones that are marked red are B, or contain the name of person 1 or person 2 referred to in order 5 below, and then number minor FEVAF, the documents titled 290,925 in provision of documents lodged in FCA.
You don't have to read them out. Just give me the numbers. F.
G. Hergels I dihydrate Vele, K. L. M. N. and O. Is what's been marked red, is sent to me in the.
All right.
Yes, so I can't respond to that as well because obviously this was sent to us after the hearing has commenced. We will need time to consider. I was listening to Mr. Kuksal's submissions, and there has been really to explain why all of those documents are added. One of them is transcripts of Justice Meagher of the 21st of May. I mean, how can they ask the Supreme Court of Victoria to suppress a transcript of the federal court,
Open court hearing.
which has been
I don't need you to barrack Mr. Kuksal.
fully in the open court? So there have been additional orders that's being sought by VLSB.
All right.
So that's why I want to ask for.
All right, that's your time. I might come back to you in a moment, Ms. Q, about your request to put on further submissions, but I'm going to hear from.
Can I just say one more thing?
Yes.
Is that? And now I'm seeking assistance from the court, if possible. I do not quite understand what is the course of justice that they say we are prejudicing. I just want a very quick clarification if that's possible.
Yes. I think I understand that, thank you. Mr. Kuksal's had a very good opportunity to address me on a range of matters. I'll think about for a moment your request to put on limited additional submissions. But I would limit you to page numbers. I would limit the amount of material you could put on.
I won't put some additional attachments. So there will be legal submissions, and then also the request that Your Honor watch the videos.
Did you say you want to put on more attachments?
I will not put more attachments.
No more attachments.
Yes.
It would be confined to submissions, and it would be in the order of 5 pages.
That's fine. And also, I want Your Honor to know my request to watch those videos because it's.
No, I've taken a note of them,
Yes.
and I've watched some of them already.
Okay, so I want to make submissions based on that and also on the open court.
Yes, okay, thank you.
Your Honor, given the time, I will keep this as brief as I can.
I'm going to put you on 15 minutes, and the buzzer will go at 15 minutes.
I accept that, Your Honor. Your Honor, the court clearly has the power to make the orders that are sought. The court has, of course, inherent jurisdiction to supervise its processes. Sections 14, 17, and 18 of the Open Courts Act give Your Honor the power to make the proceeding suppression orders that are sought.
There's no question that I've got, like, notionally, the power to do stuff.
Yes, indeed.
Let's hit the points. I want to understand what you say about the key matters that were put by Mr. Kuksal. He says there's no utility in making these orders because much of this material is already in the public domain. I don't know on evidence what is in the public domain or not, but let's assume. No, Mr. Kuksal, when I say that I don't know, I'm not saying that there isn't evidence. I'm saying I can't immediately call to mind what that evidence is, okay? Don't assume that I'm against you. I'm trying to interrogate the arguments you advanced.
Sure.
No, I don't need to hear from you now. So it is said by Mr. Kuksal that the material, I assume some of it is already in the public domain. His point is, what's the utility of a suppression order?
It may be in the public domain, Your Honor. I also do not know what precisely is and is not in the public domain. However, what the preceding suppression orders are intended to, the vice which they are intended to ameliorate, is the publication of the way that that material is deployed in the course of the interstate judge application. It is not an order which is sought to prevent the publication of that information at large.
Okay, but if it's already in the public domain, then, if I assume, as I rightly should, that the Open Courts Act means, as a policy position, what it says, courts should be open. There's no prohibition on parties putting forward irrelevant material. There's no prohibition on all sorts of material coming before this court, and then being ruled upon. If the material, even if scandalous, even if otherwise an abusive process, if it's already in the public domain, is there authority about utility?
I can't call that authority to mind as I stand here on my feet. However, Your Honor.
You know what I'm getting at. As I understand the point made by Mr. Kuksal, it's already out there. Why should the court invoke its extraordinary powers to render that material the subject of a suppression order?
We say that the court should do that because, in my respectful submission, that material is inadmissible on the interstate judge application.
That's a different.
And we will, at that application, be applying for that material to be struck out of the affidavit material, and therefore we say it ought not be before the court.
You properly foreshadow that, and you might succeed, but.
And in circumstances where the court is yet to rule on the admissibility of that material, it should not be in the public domain as part of the interstate judge application.
Okay.
We are not seeking orders to close the court. I think Your Honor understands that.
Yes, I think I've summarized what I understand Mr. Kuksal's position to be, and how he frames that.
Yes. However, how he frames that is not. The fact is that even if these preceding suppression orders are made, and the confidentiality orders are made, members of the public can come along to the hearing of the interstate judge application, and hear the way that Mr. Kuksal wishes to deploy that material in that application. The orders will prevent the publication to the public at large about how that material is deployed. But, if members of the public wish to view that hearing, then they can.
No.
Your Honor, I want to respond to what she's saying though, later.
I've heard what you have to say about this. You're biting into her time. Please be quiet now.
The course that has been proposed.
I understand what you say about that, and I understand what Mr. Kuksal says about that. I want to make sure that I have some answers to you about some other matters that Mr. Kuksal has advanced.
Yes.
So he says that you haven't put on any affidavit material from the person who's affected.
Yes. In my submission, the person who is affected is the proper administration of justice. That is the risk that we are seeking to prevent prejudice to the proper administration of justice.
Because?
Because the material is scandalous. It is unnecessarily and unjustifiably injurious to the personal character of the individuals that are the subject of that material.
Yes.
And it is self-evidently a risk to the administration of justice if material, that the admissibility of which has not been determined,
Yes, all right.
is treated as such. And S14 of the Open Courts Act states that a suppression order can be made if the court must be satisfied on the basis of evidence or sufficient credible information that is satisfactory to the court or tribunal, that the grounds for the making of the order are established.
That's S14?
It is not a prerequisite that there is any,
So your case,
that there must be affidavit material for this to be an application properly before the court.
all right. What do you say about Mr. Kuksal's point? Is that the harm that is said to arise here can't justify, or can't rise to the character of abusive process? I took that to be a second point, that the harm that's alleged here in respect of person 1 and person 2 is effectively fair comment on individuals in the performance of their public function, and that harm to reputation doesn't qualify as face, or comments about harm to reputation can't qualify as abusive process.
Nobody is alleging that there is an abusive process. First, the conduct of those persons in the performance of their duties is not on trial here. They are not parties to this proceeding.
Well, Mr. Kuksal would say it is. That's his case. Whether or not I ultimately agree with him about, that's his position.
That's his ultimate case. However, that is not his case in relation to the interstate judge application. We are not seeking these orders to protect the reputation of these individuals. We say that, 1, the matters are irrelevant. We will object to them, and we will ultimately seek that they be struck out and ruled inadmissible, and therefore they ought not be published as part of this proceeding. They ought not be before the court, because they are scandalous.
Yes. So your answer to that, just so that I understand the position when I come to articulate what it is, your answer to that is the same as you've given me before.
Yes, it is. The course that we have proposed permits Mr. Kuksal and Miss Yu to put the case in the way that they see fit. There can be, in my respectful submission, no prejudice to them in the way that they make their case on the interstate judge application.
Yes.
It is simply,
I think the point they make is, the prejudice is to the proper administration of justice if I exercise the power to suppress this material in a way that is without proper foundation.
yes, all right.
I think that's the case that he advances.
Yes, there's another aspect.
No, I don't need to.
My response to that is, as I've said before, any member of the general public can come along to watch the hearing. A member of the general public does not have an absolute right to obtain documents that have been filed with the court. They can only do so once they have been deployed in open court.
Yes.
And that comes from Rule 28.05, as Your Honor well knows.
Correct. I hear what you say about those things. Are there any other matters you want to say by way of reply?
Not by way of reply. However, I will just foreshadow to Your Honor that my instructor has informed me that regrettably 1 document and 2 videos that are referred to in Ms. Su's affidavit were inadvertently omitted from the revised documents.
Your Honor, that's not fair. We've not had an opportunity to consider that.
Just hang on a minute. My job in this courtroom is to regulate what's fair. I will give you a chance to respond. I may even just be fair to you without you having to tell me, okay?
I was objecting to her.
You can't object to a submission. You can wait, and then you'll get a chance. Now there are 2 additional documents you want to add to the list?
There is 1 document and 2 videos. As I've said, my instructors have worked incredibly hard this week.
I understand that. Ms. Tso has already asked for the opportunity to make further written submissions in relation to matters. I'm already inclined to give her the opportunity to do that, limited to about 5 pages. I think if you're going to add 3 items to the list, I should give Mr. Kuksal and Ms. Shu the opportunity to say whatever they want to say, limited to 5 pages in respect of those 3 documents.
I'm in Your Honor's hands.
Your Honor, Firstly,
In fact, not limited to those 3 documents because, as I understand it, Ms. Xu wanted to address. What were you going to say, Mr. Kuksal?
yes, Ms. Zhu did want to address the court on the wording of the Open Courts Act and things that I have not addressed appropriately in her view, so that's what she needed the 5 pages for, and she said she will refer to those videos in the submissions and how they interact with the court's discretion to establish that's what her submissions were about. I want to quickly address a few things that she said, and I'll take 2 minutes.
No,
Okay, then in writing, I should be able to.
I'm going to let you put on 5 pages, no more, in relation to the new documents that will be identified by email.
There will be a list, and all of the documents will be provided to Your Honor's chambers and the parties.
Thank you.
Your Honor, I've heard what Your Honor has to say about permitting Mr. Kuksal and Ms. Chu to provide further written submissions. I will just say for the record that Ms. Chu did not provide any reason as to why she has not provided written submissions in relation to the Open Courts principles as ordered by Your Honor prior to today.
This was an urgent application, and there was no order, Your Honor.
I didn't make any orders.
That's a lie.
That's what you said about permitting Mr. Kuksal and Ms. Xu the opportunity.
No, I did not make any orders. Mr. Kuksal, I listed your summons when I received it. I made no orders about the exchange of submissions. Mr. Kuksal put on submissions voluntarily. Ms. Gehu didn't put on submissions. She's largely accepted the submissions made by Mr. Kuksal and sought leave to address me on a discreet and narrow basis, and I've given her the leave to do that.
Because she could not make all of the submissions.
I don't need you to editorialize what I've just said, Mr. Kuksal.
As the court pleases.
Your Honor, I was saying that I also need 5 pages to address the matters that Ms. April has raised, which I haven't been able to respond to.
A single word beyond 5 pages, and I will not read it, okay?
Okay, 5 pages for the documents and then 5 pages for the
5 pages all in.
Your Honor, that's not fair. I don't even know what the documents are. If, Your Honor, I could have 10 pages in total?
No. What you're asking to do is to reply to the reply. You've occupied the court's time, making fulsome submissions, which Ms. C has largely adopted. I don't need you to make a reply to the reply. I've heard your arguments. You can respond to the additional documents which Ms. April will advise you of, that were not regrettably included in the list. You'll have 5 pages, along with Ms. Xu, to do that.
Your Honor, the Open Courts application, this was a very time-limited one. It's not our fault that it's brought in these circumstances. It's brought without any basis, and I should be able to assist the court about the matter which I think the court should hear, and I'm only asking for 5 pages, it's not too much.
No.
Your Honor, there are matters that I won't be able to raise with the court. If I could get 2 minutes, otherwise I can address them now. It won't be that long.
List me the matters.
Okay. So the first matter is that by Ms. April's count, the admissibility of documents should be addressed before the hearing, if the hearing is to take place in an open manner, or until the admissibility is decided there should be a closed court hearing of matters. That's what effectively she's saying because the only argument is admissibility. Secondly, and this is critical, they have conceded that they are not alleging abuse of process. So they are not alleging abuse of process, and the only argument that they're alleging is that the evidence in their view is irrelevant, and because it can damage a person's character, therefore a suppression order should be made. That is categorically rejected in the authorities as a basis for making a suppression order. It's also said that it cannot be made for the convenience of the court's schedule. It's basically the highest test there can be, and this does not satisfy that test. If that test were accepted, then all hearings about admissibility would be conducted in closed court because they're damaging to someone's reputation. The other matter, Your Honor, is that she said, critically, that the evidence of prejudice is the evidence of prejudice to the administration of justice alone, not to any individual. So unless the court can determine that allegation, it is an absurdity to say that, because in this proceeding there will be allegations made about judges of this court. To say that that will not bring the administration of justice into disrepute, but making allegations against officials will, that is completely illogical or unreasonable. The other point that was raised, and this is also very critical, is that it is still an open court hearing because people can come in. Well, it's a technically defined term, whether or not.
I don't need you to address me on that point.
But, Your Honor, it was said. And I read earlier that if people cannot criticize and discuss the matter further.
You've already made submission to me about that.
Okay, thank you. I just wanted to make sure.
I heard everything Ms. April said, and I understand the way you put the case, and the matters that you've just raised are already live in my head. So when I say I don't need to hear from you, I really don't need to hear from you.
Okay, and then just one other thing.
No, that's all.
Okay,
You don't need the 5 pages to address me on those matters. You can have your 5 pages to address me on the additional documents, and that is all.
Okay.
Okay?
Can the court indicate when it is or how it is contemplating in terms of the determination of this matter?
As I said, I'm sitting in the practice court. I'm hearing an injunction in less than an hour's time, and I'm occupied, I know, for a substantial part of the following week, and these matters, as you've rightly pointed out, are very important.
But, Your Honor, the court, we cannot go into the hearing not knowing whether it's going to be an open hearing.
Well, Mr. Kuksal, I will deal with this matter as the business of the practice court allows me. Now, the orders that I'm going to make from today are that you will have the additional time to put on the material for the hearing next week, as requested in your summons. The balance of your, I'm not sure whether the state parties or the VLSB has thought about the second order that Mr. Kuksal seeks in his summons, and whether that can be dealt with by consent.
Your Honor, I can indicate not by consent. There is some thought that's been going into particularly Order 2 given what Your Honor said about Order 1 already.
All right.
Obviously, as Your Honor's aware, there's a large volume of material, so the implications of the order requested are being considered.
All right, well, what I'm going to do is I'll obviously adjourn.
Yes, we take the same position, Your Honor.
So, Your Honor, then we seek leave to file all the material that's filed in one and the other.
Mr. Kuksal, I know that that's the necessary implication of, or maybe the necessary implication. I think the parties are not telling me that they oppose it yet. I think they're telling me that they're going to think about it, and having been only given, I think, the summons last night, or this morning, I'm just going to adjourn the balance of that summons until I receive and consider the affidavit material that you contemplate filing in relation to the summons, as well as, and I'm going to adjourn that, I'm not sure yet, because I don't know what is in my calendar for the practice court in the coming week, but I'll adjourn those matters depending on the business of the court in the coming week. And I'm going to reserve on the substantive application before me today, and I'll deliver my decision as soon as I possibly can.
Thank you. I just wanted to say, Your Honor, if it helps the court, we can withdraw Order 2 and just seek leave to file all the material.
At the moment, it's not with me. It doesn't save me any time yet, because at the moment, I'm leaving it to the responding parties to consider their position, and if they advise me and you that it's opposed, then you can tell me whether you withdraw it or not.
Your Honor.
Mr. Kuksal, if they advise me that it could be agreed, or agreed in part, or agreed with some conditions, and you agree to those conditions, then it might be I can make an order by consent.
Okay, we just want to have notice in advance, because the hearing is coming soon and we don't want them to. We suspect that the tactic that has always been employed, which is,
I'm not going to make an order about this, but I'm going to say that unless their position is known to you by 5 p.m. on Monday,
thank you. That's all we want.
you should just proceed as though you file the evidence in all the proceedings in the way that you foreshadow.
Thank you, Your Honor.
I'm not going to make an order about that. I'm just going to leave it to the parties to deal with it. All right?
Thank you, Your Honor.
All right.
For the submissions, Your Honor hasn't given the time, but we presume it's Monday as well?
Will be Monday.
Yes.
Of course, I can't begin to consider the matters until I receive those submissions.
We'll do it by midday Monday.
By midday Monday?
Yes, we'll do it by midday.
Well, I'll make an order to that effect as well.
Thank you.
Unless there are any other matters, the practice court stands adjourned until 2.15, but this matter's adjourned. I will say sign die because I'm not sure whether you'll come back before next week, or whether the next time I see you will be on the 27th.
May it please the court.
Adjourn the court.